The Appellate Division First Department is now in session. Good afternoon, everyone, and welcome to the Appellate Division First Department's virtual argument session. I'm going to begin by calling the calendar. As I do so, please state your name and the party you represent, and I will confirm your argument time. People versus Kazeem Cooper for the appellant.
Good afternoon, Your Honor. Angie Louie from the Legal Aid Society for Mr. Cooper.
And it's 5-1, Ms. Louie. And respondent?
Good afternoon, Your Honor. Patricia Curran for the people.
5 minutes. Huntner versus New York City Health and Hospital Corps for the appellant.
Alex Walwick, plaintiff appellant.
5-1 for the respondent.
Alina Drucker for Health and Hospitals.
5 minutes.
Thank
People
you.
versus Daniel Nader is submitted. Sunshine Partners versus Duravant for the appellant.
Lauren Handelsman on behalf of Duravant.
5-2. And for the respondent,
Michael Eisencraft on behalf of Sunshine Partners.
5-2. People versus Terrell Pass for the appellant. I'm sorry, that's submitted. Borden LP versus TBG 6th Street for the appellant.
I apologize, Your Honor. I was on mute. Gregory Clarick for the appellants.
6-2 for the respondent.
Simon Miller from Eisner LLP for the respondent.
6 minutes. Thank you.
Thank you.
Bistreak versus the City of New York for the appellant.
Good afternoon, Scott Shore for the appellants.
5-1 for the respondent.
Brian Heller of Schwartz, Perry & Heller. Good afternoon.
Good afternoon. 5 minutes. Versus New York City Health and Hospital Corp is submitted. Anima Group versus Emerald Expositions for the appellant.
Good afternoon, Your Honor.
Good
Dan
afternoon.
Zamiro for the appellants.
5-1 for the respondent.
Jonathan Cooper for the respondent, Anima Group.
5 minutes.
Thank you, Your Honor.
You're welcome. Velez versus Roy for the appellant.
Good afternoon, Your Honor. Stephen Toner representing the defendants, Candarpo Roy and Bola Taxi.
5-1 for the respondent.
Good afternoon, Your Honor. Elliot Shields of Roth and Roth for the respondents.
5 minutes. SVL versus PBM for the appellant.
Good afternoon, Judge. John Bostany for both of the infant appellants and the estate.
That's 5-2. And for the respondents.
Good afternoon, Your Honor. Sim Shapiro from the law firm of Baxter, Smith & Shapiro on behalf of the respondent, PBM, 3 minutes.
I'll state your time, but yes, 3 minutes.
Good afternoon, Your Honor. Amy Bedell on behalf of Geo Window Cleaning.
3 minutes.
Thank you, Your Honor.
Is it just Geo and PBM we have?
That is correct, Your Honor.
Okay, great. People versus Charles Osborne.
Good afternoon, Your Honor. Amelia
For the appellant.
For the appellant.
5-1 for the respondent.
Good afternoon, Your Honor. Claire Nielsen for the people.
5 minutes. Cuddy Law Firm versus NYC DOE for the appellant.
Good afternoon, Your Honor. Benjamin Kopp with the Cuddy Law Firm for the appellant.
5-1 for the respondent.
Good afternoon, Your Honor. Susan Paulson for the New York City Department of Education.
Good afternoon. There's an error there. It should just be 5 minutes. You don't have a cross appeal.
Correct.
Okay.
Thank you.
It's for the next case. Okay. So 5 minutes. Margulies versus USAA Casualty Insurance for the appellant.
Good afternoon, Your Honor. Alex Klein for Josh Margulies.
That's 5-1 for the appellant, for the respondent, I'm sorry.
Thank you.
Yes, Richard Imbrogno, Marshall Denny for the respondent appellant.
And that's 5-1. There is a cross appeal here, okay? Philanthrope versus Papa John's is submitted. People versus Bryce Sanders is submitted. 156 10th Avenue versus New York State Liquor for the appellant.
Francis Buscemi for the appellant, Your Honor.
5 minutes. For the respondent.
Is Stephen Armstrong for the Liquor Authority?
5 minutes. Schwartz versus Nola is submitted. 80 P2L LLC versus U.S. Bank for the appellant.
Good afternoon, Your Honor. Rajan Patel.
6-1 for the respondent.
Good afternoon, Your Honor. Anthony Filosa.
6 minutes. Countrywide Insurance versus TC Acupuncture is submitted. Counsel, please remember, as always, we have your briefs, we have your record, and we're fully familiar with the facts of your case, so please go directly to the most important points you wish to make. Also, as is customary, please don't speak when a justice is speaking or over each other. This is particularly important during our virtual arguments in order to hear the questions that are posed. And finally, please keep your mics muted until your case is called. We'll try to remind you if you forget to unmute yourselves, and thank you for your patience and your cooperation. The first case is People versus Kazeem Cooper.
Your Honor.
You may begin, Ms. Louis.
May it please the court, Angie Louis from the Legal Aid Society for Mr. Cooper. Your Honor, as a preliminary matter, Mr. Cooper had written a letter to this court asking for leave to file a pro se supplemental brief, and he only found out a few days ago that it was denied because it was in letter form as opposed to motion form, and he has resubmitted his motion along with a copy of his pro se supplemental brief. And we would just ask that Your Honors consider the issues he raised in his brief along with our main brief. But today I will only be addressing the issues in the main brief. We ask Your Honors to reduce Mr. Cooper's conviction of assault 1 to assault 2 and to reduce the conviction of assault 2 to assault 3 because the complainant did not suffer from serious physical injury. In this case,
with regard to assault 1, he was bashed in the head with a ladder and the skull fractured and parts of the skull were embedded into his brain. And there were months of therapy, and his friends, I think there's testimony that his personality and such have changed. Why doesn't that reach the level of first degree?
Your Honor, in order to find that there's serious physical injury as opposed to just physical injury, there needs to be a protracted impairment of health. And here the complainant actually recovered after a few months. He testified himself that he was back to normal. He was no longer on any medication. He didn't suffer from headaches anymore. He didn't have any seizures, and he was going to the gym. He was working. He himself described his health as normal. So there was no.
He may have used the word normal, but he did indicate that he wasn't able to do the same thing at the gym that he was able to do before. And people who testified talked about the change in his personality. I think the doctors as well commented on the fact that this was a very serious injury that, they weren't sure as he progressed what would happen, because there are instances such as this where people die.
Well, Your Honor, not being sure about what would happen is not enough to show that there was actually a serious protracted period of health. Here, the complainant actually didn't suffer from any of the things that the doctors thought he might have suffered from his injury. He didn't have seizures. He didn't go into a coma. And in fact, he recovered pretty quickly. His short-term memory and long-term memory capabilities were fine. And he testified himself, and I think he is the best testimony to show that he's normal now. He can go to the gym and he can work. The harm here, we can't take what might have happened as serious physical injury. Case law says that at that point during the trial, there have been courts that found where someone is walking with a limp. That doesn't rise to serious physical injury if he later on believes that he can continue playing football. Here, the complainant himself testified that he actually was normal. He was fine. He wasn't on any medication anymore. There wasn't actually an impairment even on his lifestyle. And he didn't testify to that. So therefore, there wasn't serious physical injury. I mean, we're not contesting that he was injured with the blow to the head, but that the injury itself wasn't prolonged and protracted, which is what it needed to.
And how long does it need to be prolonged and protracted? Is several months and this kind of, where he had severe headaches, all of the different medical things that happened before he got to the point where he was able to go to the gym. Is that not protracted and evidence of a serious protracted injury?
Well, Your Honor, the courts have never actually had a bright line rule on what the time period has to be. But if you look at the cases where they have found serious physical injury, usually at the time of the trial, the complainant is still suffering from the injury. So for example, where someone's jaw was broken and he was still unable to chew solid food, the courts have found that. But when you look at where the courts have overturned and not found serious physical injury, usually, the recovery taking several months, if it doesn't last until the trial, which by this time, it was only a couple of months that the complainant suffered from the recovery. But at the time of the trial, he was back to normal. He wasn't even taking any medication for anything. He was going to the gym and working. And so there was no...
I'm sorry, counsel. Would you not agree that at the time of trial, taking your argument to the next level, that the victim's ear was permanently disfigured? The injury to the ear was permanent and disfigured based on your client biting his ear at the time of the initial assault. So would that be a valid basis to support serious injury?
Well, Your Honor, first, that goes towards the second count, which is assault 2. And we're asking for you to reduce it to assault 3 because there was no protracted physical disfigurement in that case. I mean,
I'm going to let you leave it right there. We're going to go. You have 1 minute and we'll get back to you. You can finish up on that, okay? Because we're over the time. Ms. Curran?
May it please the court. My name is Patricia Curran and I represent the people on this appeal. The trial evidence.
Counsel, this was a very, I mean, to read it, to hear it, it's a horrific thing, but counsel makes a very good point. The complainant himself says he's normal, he's fine. He doesn't suffer from any lingering injuries, he's going back to the gym. What do you have to say to that?
Well, Your Honor, at trial, which was about 14 months after the incident here, the victim recounted that he still suffered from short-term memory loss and he could not even remember the specifics of the memory test that he underwent. He testified at trial that he still suffered from headaches, which could last for 2 to 4 days as a result of the defendant's attack. Now, yes, he believed that he had returned to quote unquote normal, but the fact that this is a man who's trying to maintain some optimism in the face of what was obviously a life-altering injury does not mean that the people didn't prove that he suffered serious physical injury. I'd also like to point the court to the results of the neuropsychological exam that the victim underwent in April of 2014, which found that although his memory was intact, unless he was required to recall large amounts of information presented a single time, that he had significant problems with free recall of recently learned information, and that his performance indicated significant difficulties learning and retaining new information, storing that information within long-term memory, indicating temporal lobe damage. That is protracted impairment. He obviously suffered serious physical injury as the result of the brain injury. This is someone who's a 51-year-old man who had a degree in industrial and systems engineering working as a government contractor. He did finally go back to work 9 months after the incident, but not to the job that he held. He was worried that it would be too stressful for him. Now, as to the ear injury that Judge Schulman asked about, the ear injury was 6.5 centimeters and required 13 sutures. The emergency room record stated that the ear needed to be reattached as the result of the defendant's biting it. The victim described the ear as being cut through, crushed, flattened out, and as a wrestler's ear. And the judge, who was the trier of fact here at the bench trial, obviously found that it was serious physical injury and that it was objectionable and distressing. It appeared on a prominent part of the victim's body. If there are any other questions, I'd be glad to answer them.
Any questions from the bench? Thank you.
Seeing none, thank you.
Ms. Liu, we're back to you.
Just going back to Justice Schulman's question, there are no.
Well, before you get to Justice Schulman's question, what about the comments about the long-term memory loss, the lack of acuity, the going back to a different job, the headaches? What about those things as far as protracted and serious injury?
Both the prosecution and the complainant himself admitted that the complainant suffered from ADHD even prior to having the injury. He had difficulty concentrating. He always had that.
If he always had that, he was okay to do the job he had, but then afterwards he wasn't. So there was some change that caused that, not to mention there's a difference between ADHD and not being able to remember something after the first time.
He didn't return to his job because someone else had replaced him.
Well, what about the neurological functioning?
He claims that he's normal, and that's his testimony. And there's no indication that we don't know whether the ADHD or any of his prior problems before with concentration, with memory, were present after or were made worse. All we have is his testimony saying he's back to normal and he's going back to the gym.
And with respect to Judge Schulman's question, the ear?
The only testimony we have here is that there was a scar that's described as a white polyp. And mere scars without anything more is not protracted serious disfigurement. There were no photos showing the injury before. And when we're talking about—
Well, there wasn't an injury before. Presumably, it was you meant the injury.
I meant showing the injury at the time that his ear was injured. But it was reattached back. When we talk about serious physical disfigurement, we're talking about loss of function or amputation, neither of which happened. He can hear.
But wasn't his ear amputated in essence when your client bit part of it off?
And they were able to reattach it to a point where the only description of the injury was a scar that was described as a small white polyp, which the judge did not even comment on when he was shown the scar himself. And for those reasons, Your Honors, if there are no further questions, I ask that you reduce the assault 1 to assault 2 and the assault 2 to assault 3.
Thank you. Thank you very much. Thank you both. Hunter versus New York City Health and Hospital Court.
May it please the court, Alex Walwick for the plaintiff appellant. Your Honor, the issue in this case is put very starkly in the sense that in today's computerized age, everything's electronic, and the fact that audit trails of electronic medical records are required to be kept by law. The audit trails or other metadata are part and parcel.
Are two very different things, right? There was no separate request made for this identifying what was required, but I don't even think that there was the judge didn't actually speak to the merits of this. I think you brought a motion to renew based on the fact that the second department reversed a decision that the judge relied on, but the judge distinguished the cases and said that this was not, the facts were different. There was no new law here.
Well, I think actually the court below had directed plaintiff's counsel to make his motion to renew after the Vargas case came down. So I think if there's any question about the court's jurisdiction to hear this case because of a motion to renew, I think it's satisfied. No one objected to the court accepted the motion. He granted renewal, but adhered to the original determination as in a re-argument motion.
It's not a jurisdictional issue. It's a question of, was there any change in the law which would warrant a different result? No one's debating that you had a right to bring the motion. Just what about Vargas? Was a change in the law versus just that it was a factually different case?
I think it was sort of reasonable for the plaintiff to believe that there was a change in the law, because in the lower court's decision here, he relied on the Vargas lower court decision itself, which was reversed in the Second Department, which I think made it appropriate to bring a motion to renew based on a change in the law, where there's very little.
Counsel, this is Judge Singh.
Yes.
Counsel, why is the metadata material and necessary to any of your claims in this case?
For one thing, it's part and parcel of the electronic medical records. They're the same. They're made at the same time.
My question is, why is it material and necessary? Not that it's part of it. Is there, for example, are you making a claim that the documents you have are forged or incomplete, or there's discrepancy in them, or anything like that, where maybe arguably the metadata would help?
Well, I would first say that being that they are part and parcel, and you can't know what you don't know. So the metadata is discoverable because it allows you to determine if there is something that's material and necessary in the first place. But if you're talking about a factual predicate, the plaintiffs pointed out below that in many instances in the operating doctor's deposition, she made several references to the fact that her notes did not contain any references to preoperative, prophylactic, or perioperative antibiotics being given, yet the EMR, the electronic medical records, did show that they were given. So I think that given that the discovery is so broad in the state, material and necessary does not mean indispensable. It's legitimate to determine whether the metadata, the audit trails, show that the reference to the antibiotics was a later entry, so to speak. And metadata show whether there's been modification or alteration and editing, even if innocent, to the EMRs. So that by itself makes it legitimate for discovery.
Thank you. Any other questions? Thank you. Ms. Drucker? And by the way, if anyone has who is a non-speaker is unmuted, please be sure to mute yourself. Ms. Drucker?
Yes, Your Honors. Good afternoon, Alina Drucker on behalf of H&H. That's absolutely correct. As you noted, the Vargas decision, first of all, does not work the kind of sea change that even would allow the court below to grant renewal and to reconsider the prior decision. But even if it had, there's absolutely no relevance here. And in fact, the renewal papers didn't even attempt to address relevance. They just said that they believe that these records should be produced because they're part of the electronic records. And that's also just inaccurate. I know counsel had mentioned, in this day and age, but this is an incident that took place in that hospitalization that took place in 2013. The medical records that were produced, the electronic medical records, are not part and parcel of these audit trails. These are completely separate records created in a database that have to separately be accessed. So they're not part of the record. And to produce them, there needs to be some minimal showing. I mean, just an iota of showing of relevance even would be something, but that's not the case here. There's no allegation that anything was improper. There's no evidence suggesting, and this is, by the way, at the end of discovery. We're talking about, there were 3 depositions, I think 20 hours, over 20 hours the doctor sat for deposition. So there was no indication at any time during this sort of pretty sweeping discovery that there's any issue that could be revealed from these audit trails. The only real question that the plaintiff has now sort of put forward is this question about handwritten notes, that the surgeon's notes don't reflect having administered antibiotics, while the anesthesiologist's notes do. I think it's quite clear that the anesthesiologist's notes reflect what the anesthesiologist did and the surgeon's reflect what the surgeon did. There's no sort of question created by that would be answered in any conceivable way by the audit trails production. So there's no basis to grant it. And that's why the the trial court exercises broad discretion and denied it. And we'd ask you to affirm. So you have further questions for me.
Any further questions? Thank you, Ms. Drucker.
Thank you.
Just very briefly, I think it comes down also to a question of fairness. This is information that the defendant has, that only the defendant has, and won't allow to be discovered. And I don't think the plaintiff should have to say, well, we'll accept the fact that that the information that you have is not helpful to us, and just leave it at that. I think that it's legitimate for cross-examination purposes, and I think that at the very least, the plaintiff should be allowed to the audit trails regarding at least the administration of the antibiotics. If the defendant says it's too expensive, too cumbersome, which is I think in a conclusory affidavit to that effect, but if they say that, then at least give us the audit trails pertaining to the antibiotics that were given or not given, as the case may be, and as the audit trails may determine were not.
Thank you. Thank you both.
Thank you.
Sunshine Partners versus Duravant.
Lauren Handelsman for Duravant. If it may please the court. Can you hear me?
We can hear you, yes.
Okay, great. So the contract at issue here that you're already familiar with provides for an opportunity to be engaged and is not itself an engagement agreement. So when we turn to the question of whether certain aspects of that NDA are insufficiently definite to be enforceable, we're examining the terms that would potentially apply after and only if Duravant actually offered the opportunity to Sonnenschein Partners to be engaged, and after the parties engaged in future negotiations regarding applicable terms and conditions of that engagement. Yet Sonnenschein claims that the NDA here retains it as a full-service buy-side investment banker for the acquisition of Wolf Tech, entitling it to a 1% deal success fee. Not a single one of those terms appears in the NDA. There is no reference to the level or scope of services to be performed, no reference to the specific role that Sonnenschein Partners would carry out. It doesn't even
Counsel,
reference
even if we ultimately agreed with you that it was too indefinite to be an enforceable agreement, why wouldn't there be a potential recovery stated under quantum merit unjust enrichment?
Well, primarily because we have a statute of frauds problem here, as the motion court recognized. You know, the statute of frauds applies to the circumstances here because under Section 5701A10, services that are rendered in negotiating a business interest.
Now, just interrupt, because this is a motion to dismiss, so we have to accept the allegations as true. And looking at the allegations of the complaint, they do appear to allege that they were performing work aimed at informing Duravant whether to purchase the company, which is not a finding fee that would be barred by the statute of limitations. So why, for purposes of motion to dismiss, what would it be barred by the statute of frauds?
Well, respectfully, I think that the facts alleged do not fall in the category of services that are not part of negotiating a business opportunity. I know Sonnenschein claims that in its brief, but if you look at the actual allegations, the very beginning of these parties' relationship was the introduction of Duravant by Sonnenschein Partners to an alleged insider of a company that is the target or the purported target of this acquisition. And all of the work that was performed by Sonnenschein as alleged in the complaint, and only as alleged in the complaint, is related to that acquisition and that acquisition only. There were no other services performed. For example, this case is entirely unlike the services in Dorfman versus Refkin, where the services performed, some of which related to a business acquisition and some occurred after the business was acquired. Here, these all relate to an investment banker trying to get one type of deal done. And in fact, the fee that was paid here is a success fee. The fee sought is only a fee that relates to the actual consummation of the deal at issue. There's no advisory fee for other types of work. They're looking for a 1% deal fee, which means the deal happens and you get a fee because you were successful in negotiating the business opportunity.
Any other questions? Thank you, Ms. Handelton. Mr. Eisencraft?
Good afternoon, Your Honors. This is a very simple contract between two sophisticated parties. The head of Sun and Shine Partners and the head of Duravant had three conversations. First of all, the head of Sun and Shine said, "We'll set up this meeting, but if we do, you have to hire us as your banker." On April 28th, Duravant said, "Sure." April 30th, same conversation, same result. He said, "Sure." And then we have to memorialize it. So they did. Very simply.
But are there definite terms in the agreement, in the NDA, that allow this to be something other than an agreement to agree?
Absolutely, certainly. First of all, the role as financial advisor, that's a term of art in the investment banking industry. Everyone knows what that meant. These are two repeat players who have been down this road a number of times. Second, it refers to customary and market terms and conditions. As this court recognized in other cases, this is investment banking. It's
what about the statement that says based on the terms to be negotiated later? What does that mean?
Well, in investment banking, the customary market terms and conditions are based largely on the size of the transaction. So given that they don't know what they were buying from the Malis Group or what they were paying, you can't really negotiate an exact fee at this point in time. So what happens is the two parties do fee runs for a transaction of this, whatever the size turns out to be, in this case, $250 million. And they say, and for $250 million, we assert in the complaint, it's a 1% deal fee, and they negotiate around those margins. But it's very standard.
Isn't there a problem that it doesn't anywhere say in that memorandum that they're actually, we will hire you? It just says we will use commercially reasonable efforts to hire you, not that we are hiring you as our financial advisor.
Well, it says that we will use our commercially reasonable best efforts, and we can't really ask for more than commercially reasonable best efforts. I mean, that's about as, they're doing their best to offer us the opportunity to work as their banker. And the allegations of our complaint are so far off that they didn't do anything. We did the work they asked us to do, and then they just went silent, and they did the deal without us.
Counsel, this is Judge Singh.
I'm sorry, go ahead.
Could you address the quasi-contract claims? Your adversary says that all you're seeking is a transaction fee. Is that correct, or are there allegations in your complaint that would support the statement that you're seeking actually monies for the services, the professional services that were allegedly provided?
The second, Your Honor. As we allege, so there are two parts for a transaction. One, the negotiation itself, and we were not given the opportunity to participate in those negotiations except for one phone call. The work that Sun and Shine did was to provide the meeting with this insider, which gave them valuable insight into the company they were thinking about whether to acquire, and did research about the companies. In other words, information that Duravant used to decide whether or not to negotiate and at what price to negotiate. We weren't involved in the negotiations. We weren't given that opportunity. So yes,
you have a cross appeal. I guess, why don't you address that if you already haven't?
Sure. That's of the Quantum Merowith claim. Justice Cohen has said that dismiss it because it's basically redundant of the breach of contract claim. And
it's the last question that actually Justice Singh asked about, right?
Yes. So we don't think it's duplicative we're allowed to plead the alternative at the pleading stage. The one case that Justice Cohen cited saying that, if it's duplicative, you have to be out is at summary judgment. We're entitled to build our factual record, and then, at some point we have to make a choice, or the court makes a choice for us, but it's not the pleading stage. At the pleading stage.
I'm going to go back to Ms. Handelman.
Of course, Your Honors.
I have just 3 quick points, Your Honors. First, to address the concept of future negotiations, I'd just like to point out that the language of the NDA itself refers to future negotiations, not just as to price. The concept of price and fee appears nowhere in the NDA. It's the entire engagement that would be negotiated in the future, and agreements to agree to something in the future, the Court of Appeals has held, are unenforceable agreements to agree. Second, to Justice Singh's question about the quasi-contract claim, the damages sought pursuant to the quasi-contract claim are identical to the contract claim. There is no difference. There is no allegation here that there was a specific piece of the work that was done that should be valued in a certain way other than as a success fee of 1%. They're identical. And third of all—
But isn't that something that can be developed in discovery? Because there is an allegation, I think paragraph 70 of the complaint, where in the second cause of action, where the plaintiff is seeking monies for professional services provided.
So the allegations as to the substantive work is identical to the substantive allegations of the work that would be recoverable under the contract claim. And as a moving into the last point I quickly wanted to make, the claims here are duplicative, and the quasi-contract claim is barred because there is no dispute that there's a valid contract here. What's in dispute is what that valid contract provides and states, and the rights and responsibilities of the parties thereof.
But couldn't one look at it that the contract claim is looking for a 1% transaction fee, and the quasi-contract claims are looking for the claim is different. It's looking for the services that were provided to your client with respect to the purchase of the company.
No, because every single allegation about what Sun and Shine Partners did is the exact work that's related to the claim for the success fee. There's no separate set of facts that are alleged. They're all in one basket together.
Thank you.
Thank you. And Mr. Eisencraft, do you have 1 minute?
Yes, very briefly, Your Honors. This is Cowan and Company. This First Department decision from 2016. Same terms, same situation, two sophisticated parties. They knew exactly what they were bargaining for. We delivered our half of the bargain. They did
but
not.
Didn't Cowan counsel refer to a transaction fee?
It said,
I recall from reading it. I think Judge Renwick wrote it, so she probably remembers it better than I do. But
it said transaction fee consistent with investment banking industry practice for transactions of comparable complexity, level of analysis, and size. I mean, functionally, ours is our contract says financial advisor with respect to a transaction on customary market terms and conditions. I think that's a distinction without a difference.
So what's the objective standard by which we can supply those terms? In Cowan, there is a basis. In this case, what's the basis? What's the objective standard?
Same basis. You do a fee run.
There's no reference. There's no reference to a transaction fee, right?
There's no reference to a fee run in Cowan and Company either. Both sides knew how to calculate this. This is not, no one's a babe in the woods here. You do fee runs and you get a result. Then they're talking about a transaction here, and they specify the type of transaction, and it's just, it's customary market terms and conditions. I don't think Duravan can say, surprise, we thought you were working for free. No, they knew what they were bargaining for.
Thank you. Thank you both.
Thank you, Honors.
Thank you.
Borden versus TPG 6th Street.
Good afternoon, Your Honors. This is Gregory Clarick for Appellants TPG 6th Street Partners and PBB Investments. Respondents Borden LP and its principal Michael Borden's below market sale of the credit agreement's collateral, the switch units, from Borden LP to a newly minted Michael Borden owned and controlled entity violated the appellant's rights to buy the switch units and violated the appellant's rights separately to immediate payment.
Counselor, this is Judge Singh. With respect to the first offer, was your first offer sufficiently definite so that it could be determined objectively what the number? You have a 20% discount rate, but the other aspects, are they sufficiently definite? What was going to occur in the market some 60 days later, I think?
Yes, Your Honor, that offer was absolutely sufficiently definite to be viewed as an appropriate price term. There was a 60-day bidding period that was set by the agreement itself. It said that Borden had to accept the highest price, the highest offer that it received within the 60-day bidding period. Our client's offer was based on a 4-day average to be calculated just before the close of the 60-day bidding period. So by day 60, the amount would absolutely be known. We would multiply the number of switch units to be purchased by the average price over those 4 days, and a discount of 20% would be applied to it. And as it turned out, that number would have been $81 million. And what's interesting with respect to the use of the discount, also, among other things, is that Borden itself sold for a discount to its own affiliate, PRS 1000, whose valuation expert applied a 31% discount. So they too are looking to a discount as a means of putting a price on the switch shares, and their discount, yielded a number that was $10 million lower.
So is that sufficient? Just using the 20% versus the 31.7%, is that sufficient to show that there was a breach of the agreement?
Well, with respect to the first offer, the breach really occurred when Borden rejected the first offer, which happened a week after the offer was made. The offer itself was for a 20% discount to be, calculated at the end of the bidding period, and the number of units to be bought, the price, meaning using the average price at a 20% discount, was set forth. And so it was a sufficient offer on October 13th, 2017, when it was made. It really doesn't lead, it was wrong of Borden to reject it a week later as insufficiently definite. Does that answer your Honor's question?
Thank you. And
I think importantly, the credit agreement didn't call for anything more. It didn't say that the price that the price term had to be of an offer had to be set forth in a dollar amount. It simply said an offer, and that certainly was a sufficient offer. Borden complains as well that they couldn't use that discount as a marketing or as a gauge in the marketplace to get other offers or compare it to other offers, but that's just silly. This is the sale of tens and tens of millions of dollars of switch units in a very sophisticated market where the players would be able to compare the discount we offered to the discount to any other price or any other supposed discount.
So what you're saying, I think, is that in other words, whether you have to wait the 60 days to determine the precise amount, that's really not necessary. It's just looking at the discount rate is sufficient. Is that what you're saying?
Well, I think the sophisticated players in the marketplace could certainly look at the discount and gauge whether, what offer to make against a 20% discount offer at the end of the 60-day period. In fact, the days on which that our offer would have been calculated would have begun on November 20th, I think. It would have been 20th through the 24th, which was exactly the day on which PRS 1000, Michael Borden's affiliate, claimed to have made the purchase at a 31% discount. So, offers would be readily comparable at the close of the 60-day period. Absolutely. Secondly, yes, Your Honor, Justice Renwick?
Go ahead.
Secondly, our clients' appellants made a second offer just days before their first offer having been rejected wrongly. They made a second offer late in the bidding period, a few days before its close, for an absolute price.
Well, wasn't that too late? Didn't you have 10 days to make the offer?
The way we read the agreement, and certainly the way our clients understood it, they had 10 days to make an initial offer, which they absolutely did. But there was nothing in the agreement that barred them from making a second offer.
But what's the point of 10 days then? If
the point of the 10 days is to get an initial offer on the table that Borden could use in the market to gauge competing offers, and frankly, to decide whether to sell at all, because Borden wasn't required to sell. It's just that if it did decide to sell, it had to sell for the highest price that it received. And when it received the $88 million, that was clearly the highest price that it received. The PRS 1000 note that it received was for $71 million. Obviously substantially less. And the construction of the agreement to throw out the $88 million offer makes no sense. Borden had to take the highest offer that was on the table, and it should have, had no legitimate reason to turn down our client's second offer.
Mr. Clark, this is Judge Shulman. At the end of the day, the loan was paid off with interest. So the fight, and I say this respectfully, is really over about a difference of $12 million roughly.
Well, no, Your Honor, the fight is over, we believe over 20
Well, the percentage, well, that's my point. In other words, the Borden company attempted to preempt by offering you $12 million, and you calculated based on the higher value of this of the switch unit as being about 22 million. I'm being overbroad, but you get my point. So that the whole fight now, since the loan has been paid off with interest, is the value of that percentage share, which appears to be a willingness to pay. Just how much? Would that be a fair statement?
That's true, Your Honor. The fight is over how much the switch sharing percentage is. I would say very importantly, the switch sharing percentage was the key to this credit agreement. This wasn't an ordinary everyday loan. It was a loan that was made to help Borden LP monetize its interest in these switch units. It was a low interest loan, and the lenders made it, and our client bought the loan from Credit Suisse for the exact purpose of investing in that kicker payment, because that's where they took risk by giving Borden LP and Michael Borden for $12 or $13 million, whatever the amount was. There was real risk, real credit risk, but the payoff wasn't in the couple percentages of loan interest. The payoff was going to be in this kicker payment. So it's extremely important that this payment be paid. And really, my second point, what it is in a separate breach, is that payment was due under the credit agreement expressly upon a sale and promptly after a sale of the switch units. And that was—
Thank you. You have some rebuttal time. I've let you go over. Thanks, Mr. Miller.
Good afternoon, Your Honors. May it please the court, Simon Miller. I'd like to go directly to Justice Singh's question, because Mr. Clerick's answer is predicated upon a fallacy. There is in the agreement no 60-day bidding period. That is just something that they have.
Put aside the that issue.
Yeah.
The offer says 20% discount rate. Right. OK, we may not precisely know what the exact number is going to be because it depends on market conditions down the road. Your offer is 31.7. Why is that not a straight breach of the agreement? Because you don't sell it to the highest bidder.
Because, Judge, the offer that was made in October of 2017 said it's going to be 20%. A 20% discount off of whatever the market price is 60 days from now. Okay, so in October,
can that be objectively? Let me stop you there for a second. Can it be objectively determined?
Not on October 13th. It can't, because nobody knows what the stock market, the price of this stock, the publicly traded price for the stock, because that's what we're talking about here. The publicly traded, this stock that we're talking about here was not publicly traded. It was private. And
there's going to be an IPO, right? There's about to be.
No, there was an IPO. No. Just to be clear, and this is a little bit confusing. I acknowledge, and Mr. Clerick would probably agree with this part. As of October 13th, the IPO had taken place, but our stock that we held was not yet public. For two reasons. We held private stock that had to ultimately be converted into the public stock, and we were subject to a lockup agreement. We couldn't sell our stock. We couldn't even start the process of converting our stock for at least 6 months, which is why this whole refinance was necessary, because they wouldn't extend our maturity date, which was well before that 6 month expired. So what the 20% was a discount off of what the publicly traded price would be 6 weeks down the road. We didn't know what that would be any more than I know today what the stock market's going to be tomorrow.
Judge Kern, why wouldn't you be able to compare it, though, to any other offer that came along, just as you could ultimately compare it to the offer you did accept, which was a lower offer, because they would also be doing it at a discount rate, and you just compare the two discount rates?
Respectfully, Judge, it was not the same type of offer. The deal that was done was a discount based on the day of the sale. There was, because, in other words, that what Borden LP did was said, we're going to do a refinance. We're going to transfer the stock in order to refinance it, meaning take out a loan using the collateral, which is something, by the way, that the court acknowledged was appropriate and allowed under the agreement, and it is not disputed here that we were allowed to do that. And so what we did was we said, well, we have to transfer it technically, But we need to know what to transfer, the price to transfer it at. And so we set a specific day, the day in which the transfer would occur, and said we're going to apply the discount at that point. So in other words, the valuation expert calculated the discount as of the same day as the transfer took place. Here, they put a discount and said it's going to be based upon some future price. Ours was definite, theirs was not definite. On October 13th, I couldn't know what the price was that I would receive until 60 days later.
But 60 days later, you certainly could calculate that, and then you could use, as my colleague is suggesting, look at the discount rate versus what the defendant is offering and what others would offer. No?
But Judge, that basically would force me to wait 60 days, and the agreement doesn't require me to do that. If I can read from the agreement, it says that my client was entitled to sell these units, quote, at any time. All I had to do was give them 10 business days advance notice, meaning I could sell it on the 11th day. I could sell it on the 11th day. So on October 14th, I could go forward with the sale.
Counsel, what?
And what was their requirement at that time? I mean, their requirement.
They didn't have any requirement, Judge. All they had, if they wanted, I say to you, on September 29th, I'm going to sell this. I'm giving you 10 days notice that I'm going to do this so that you have the chance to bid. They had then the opportunity to bid. They didn't have to.
But they come in on the 10th day. And I mean, well, it's already been said, there are these factors that could have been determined. I mean, it wasn't completely vague. It could have been decided. It was a question of whether or not you were going to play that out or go elsewhere.
But Judge, that would have required, the whole point was that that they were supposed to give us a number that we could then go out to the market to compare.
So, but your adversary says you do have the number. You have the 20% plus what's going to happen in 60 days. This is a sophisticated market, and it could be evaluated. Isn't there some logic to what the defendant is saying here?
But that's not what the agreement provides for. The agreement does not provide them the right to continue to rebid or to force me to wait.
What agreement prohibits them from doing this? Where in the agreement does it say they can't do it 60 days out? Is there any prohibition in the agreement that says, no, you can't do it for a day 60 days out?
What it says, Judge, with respect to that is that my client was entitled to sell at any time. We didn't have to wait 60 days. They could certainly
But they had
offer.
they had the right to make that bid first. And they did it. So as much as you're saying you had the right to sell the next day, they also had the right to present this to you. And if it had the ability to come up with, definite terms, then given that they presented you with this, you had to then give them the right to have that come about. It seems like that was their giving you something. It did technically have definite terms. Why wouldn't you have to then allow that number to bear that out?
The answer is in the agreement, Judge, in the language of the agreement. I hear you, Judge. And the answer is in the language of the agreement. It expressly says we were under no obligation to accept their offer, take their offer, consider their offer. We weren't. It says it right in the agreement. If we wanted to, and this is what the 60 days is he's referring to, if we wanted to, we had to close within 60 days from our notice, not 60 days from their offer, 60 days from our notice, because obviously their offer wasn't going to stand out there forever. Now, as it happened, we rejected their offer almost immediately for the precise reason that, one, not only, by the way, did they not have a price term, they didn't tell us on the form it was going to be paid. They didn't tell us, for example, whether it was going to be cash, whether it was going to be a promissory note, whether it was going to be paid over time. All they said was customary terms. Now, that's fine. In an offer, that's fine. They could make their offer whatever they wanted it to be, but we weren't obligated to accept it, and they were not able to force us to wait the 60 days. The 60 days refers to if we're going to go forward, you got to close the thing out. That's what it refers to. But if we decided, for example, that we wanted to do this transaction, if we'd set it up ahead of time differently, and we wanted to go do the transaction on October 14th or October 15th, this agreement allows us to do that. And the only question would be whether we gave them the opportunity to bid. But it expressly says we do not have to give them the right to do anything except make a bid, and then we can either accept it or not accept it and go forward with it however we want to. That's what the agreement allowed us to do.
Are there any further questions from the bench? Okay.
Thank you, Your Honors.
Thank you. You have 2 minutes, Mr. Clark.
Thank you, Your Honor. I have 2 points I'd like to make. First, Mr. Miller said, and these sort of are all akin, he said they could sell at any time. They could sell on the 11th day. The 60-day provision set a time to close. Those are absolutely incorrect. The agreement is crystal clear that it sets a 60-day bidding period in paragraph 5.06b when it states that to the extent the borrower elects to consummate the sale of any or all of the offered switch units, the borrower shall sell such units to the person or persons, if applicable, who offers the highest price per switch unit within 60 days of the notice. The within 60 days of the notice clearly and unequivocally modifies the phrase, the person who offers the highest price. And it sets a 60-day window. And in fact, the court below referred to that as the 60-day look-back period in which they had to take the highest price. And that's why our clients made an offer that could be calculated within that 60-day period. And it was 100% objectively definitive and objectively, determinable. That's first. Second, just to follow up on the point that I began before, totally separately, the agreement requires in both 5.06b and d that the switch sharing percentage be paid upon or promptly after a sale, period. Even if their PRS 1000 sale on November 20th, 2017 is valid, and again, obviously, we think it's not.
Are net proceeds, is net proceeds a defined term in the agreement?
Net proceeds is not a defined term.
So then why is your position correct? If there's an ambiguity, wouldn't that be really an issue for trial?
Well, if Your Honor is, we think it's unambiguous for the reason that
you're conceding that net proceeds is not defined. If it's not defined, then maybe a note's okay. I don't know.
Well, what's okay is that the net proceeds, or what's clear is that net proceeds refers to the delivery that's made for the sale. Any other interpretation of net proceeds would really trample the fact that both of those provisions state that the payment will be made upon or promptly after the sale. And that wasn't unimportant for the reason that the credit agreement is a non-recourse agreement, meaning to the extent that money is owed to our clients, the recourse is only against the collateral. And because the recourse is only against the collateral, the payment of the switch sharing percentage has to happen at or about the same time as the sale of the collateral. If that doesn't happen, our client's ability to collect on the switch sharing percentage years later, like we're looking at here with respect to the note, will be, incredibly hindered or will be burdened in a way that clearly was not what the parties intended. Thank you.
Thank you both. Mr. Miller, thank you. Thank you both.
Thank you, Judge.
District versus the City of New York.
Good afternoon. May it please the court. My name is Scott Shore and I represent the appellants. The Supreme Court should have dismissed Mr. Biestrick's claims against former City Council member Gentili. First off, there's no tribal issue as to whether Gentili disciplined Biestrick because of his disability. Councilmember Gentili hired Biestrick while aware of his Asperger's. He entrusted him with significant responsibilities and high-profile assignments, including a delegation to vote in his place during a meeting with the Brooklyn delegation, also gave him a $6,000 raise. Although Gentili made some insensitive comments during the employment relationship, the turning point was in early 2016. That's when Biestrick, the budget director, decided that he was going to take a vacation during a key week of the budget season, a week when Gentili was relying on him to be fully available.
When did the plaintiff get authorization to take that vacation?
The authorization was granted in January, about 6 months before.
So presumably, you know, I don't know about you, but people make plans, buy airline tickets, or we used to in a different world, resorts, all that. So why wasn't it reasonable for the plaintiff to go ahead with his plans when he was granted permission to go during the budget period?
Well, everyone had forgotten about his vacation, and yes, it may have seemed reasonable to allow him to go ahead and take his vacation. But what happened, what was different from the other early June vacations he had taken, and he admits this on page 356 of the record, is that the budget schedule was accelerated. When Councilmember Gentili found out that his key budget guy was going to be out of town during a key week of an accelerated budget cycle, and that he had been silent about it, he flipped, and his text messages show how livid he was. He thought this was a betrayal. He thought it was abandonment, disloyalty.
Sorry to interrupt you, but this wasn't the only instance. There were numerous instances that the plaintiff alleges that would show discrimination on the part of Mr. Gentili. There was the laughing at a joke that someone outside of the office had made with regard to locking a door or something like that. There was this repeated expression of annoyance of the plaintiff's tics and about repeatedly asking about medication and whether he's treating these things. There was the potentially paying the plaintiff less well than the other similarly situated employees in the office. And then finally this demoting him and ultimately terminating him and not giving him his vacation. Aren't those things that could reasonably be concluded that perhaps Mr. Gentili was getting increasingly annoyed and embarrassed and frustrated about plaintiff's autism?
No, Your Honor.
And that it really goes to that?
No, and for several reasons. First of all, context is crucial, and this court noted in Hernandez the importance of context. And the context here is that although those comments were made, they preceded continuing favorable treatment of Biestrich by Gentili. After two of the comments, he got that very prestigious assignment to represent.
I'm sorry to interrupt you, but what about the salary? As my colleague pointed out, wasn't he getting less than others for the type of work that he was doing as the budget director?
He hasn't made that out, Your Honor. He hasn't created a fact issue as to that.
You're saying, well, I'm saying he hasn't made it out because it hasn't been asserted, or you agree that it's been asserted, but it doesn't create an issue of fact.
The latter, Your Honor. He asserted it, but there is no tribal issue of fact because of this court's decision in Urugairen, which he completely ignores in his brief. And that decision talks about what you have to be able to show to identify a valid comparator. You've got to find someone who has similar work experience, similar salary history, similar job responsibilities.
What about his junior? Wasn't his junior chosen? Yeah. What didn't he get his assignment? And
after
did the junior ultimately get more money than the plaintiff was getting?
Ultimately, after the vacation incident, Shabshakis, who had gone from part-time to full-time, did obtain the title of legislative director, and I believe later, after Biestrich left, he did get a raise along with everybody else.
But this person came in.
I'm sorry. Go ahead.
No, the junior came in after this person, the plaintiff, had already been working there, and it was acknowledged that the plaintiff had more experience in budget than anyone else. And yet the person who was junior to him, because he took vacation, a vacation that was planned out to him, someone who was junior was passed over him and his bonus was taken away and all of this. I mean, I think you were going to say before that the councilman even allowed this person to vote for him. Wasn't it after he had been making a lot more public appearances and coming out in public that one could argue, as they have, and perhaps a jury would find, that it was really after a lot of these public appearances that the Gentili was getting frustrated and embarrassed and led to this ultimate firing as a result of embarrassment over the tics and the autism and everything else?
Two quick points, if I may. I know my time is up. First is that two of the comments preceded that high-profile assignment. Biestrick gets the timing wrong in his brief, and I can give you the record site if you need to check it. The second point is, even after the discipline he received for taking that vacation during the key budget week, it was clear that Councilmember Gentili expected Biestrick to continue performing these high-profile public-facing responsibilities. So that theory that this was all part of an effort to remove Biestrick from these positions because of his tics, it's completely undermined by Biestrick's own admission that he was expected to continue performing these duties.
Okay, thank you. Mr. Heller?
Thank you. May it please the court. I just want to put some of these arguments about the vacation in perspective. So Michael Biestrick is hired and he's brilliant. His work is deemed brilliant. He's grossly underpaid compared to his comparators. The chief of staff said that he was underpaid, and he said he even spoke to Councilmember Gentili about Michael being underpaid, but that there was always an excuse for Michael being underpaid. In February of 2016, a month after the vacation is approved, Councilmember Gentili pulls Michael in and says, we're going to give you more responsibilities, but your tics are unnerving to people. And can you up your medication to stop them? And he's red in the face and he's pounding the table, which Michael thinks means he's been thinking about this for a while, because he is getting more responsibilities. A couple weeks later, a couple months later, he comes and he says, did you look into upping your medication? Michael says, again, you can't do it. And then in June, there's a third conversation where Councilmember Gentili says, you got to up your medication. And then later on that day, they're told that the person who had been his assistant is now going to be taking over much of his legislative responsibilities.
Before we go on, go ahead.
And then this is the same day that Michael allegedly does not tell anybody about his vacation. So there's 3 instances over a period of months where they said they want to give more to Michael. They sent him to that meeting, which defense counsel really misconstrues as some plum assignment. And then this vacation comes and the council member overreacts. His chief of staff said he overreacts, and then he fires Michael Biestrick.
Can I stop you for a minute?
Yes, please.
What precisely, and I'm sorry, I'm having feedback. What are your claims in this case?
Well, the claims is discrimination. Is that Michael Biestrick was discriminated against because
you bring that under what? This discrimination claim.
That's just the city law. That is just the city law. The only law against the city. So the claim for discrimination is against the plaintiff's employer, the city of New York.
So you're saying, I'm sorry, you're saying that you have a direct claim for discrimination against Gentili, aside from the aiding and abetting claim, or what?
No, I'm sorry. No, we just have a claim for discrimination against the city of New York. There is a second claim against Gentili individually for aiding and abetting that discrimination. Now, defense counsel.
So can you bring an aiding and abetting claim if you have to have knowledge, right? Don't you have to prove that the person knew about all the various things that they aided and abetted in?
No, well, we're not looking to assert a claim against Gentili for aiding and abetting things he wasn't aware of.
Okay, so
he's aware of his own conduct, and it's not that
own conduct.
Abetting, I'm sorry.
Yeah, no, I mean, you're saying that he aided and abetted in the kinds of things that were going on in the office, right? All of those different instances.
So
doesn't he have to be aware of those?
No, and we're not necessarily saying that, but for his own conduct, for the.
But sir, you can't. Can you aid and abet
yourself
your violations?
Right, now that is an argument that is really taken out of context by the defendant in this case. What that means is that aiding and abetting is not a freestanding claim. You first have to have the claim against the employer established before you can have an aiding and abetting claim. So in this case, they can see that there's a claim against the city. This is not the derivative claim is against Gentili for aiding and abetting the city's conduct.
Now, this is Judge Kern. Why have you not asserted direct claims against Gentili for discrimination in addition to your direct claims against the city?
Because it used to be that the fight was always that the individual, the supervisor in this case, was not the employer. So there was always a fight over getting the supervisor in directly. So you brought an aiding and abetting claim.
So what about the city human rights law? Did you bring the claim that my colleague just referred to, an individual claim against Gentile under the city human rights law?
We did not. Frankly, this is not an issue that generally comes up as far as an individual defendant trying to weave their way out of a claim. We certainly can still move to amend the complaint. That might be something that we should do now. But when we look at the aiding and abetting claim, this is the case where the aiding and abetting claim is appropriate, because it's the aiding and abetting your own in conduct is where you are the only employer. And here the employer is the city. The city is the employer of both Bistrict, of Gentile, of all the employees in that office. And so council member Gentile, through his actions, aided and abetted the city's discrimination. And that's what the Second Circuit held nearly 30 years ago in Tomka. And the defense counsel, the city in this case, completely ignores Tomka. But Tomka holds that an individual can be liable for their own conduct under an aiding and abetting.
But isn't that's inconsistent with our case law? In Hardwick, we say an individual can't aid and abet his own violations.
Well, Hardwick said, in Hardwick, the underlying discrimination case against the employer had already been dismissed. And so the court held you don't have a freestanding claim for aiding and abetting separate and apart from the underlying discrimination. So in this case, it's completely different. We do have the underlying claim. And if you take away the aiding and abetting protections, then it really guts the law completely, because you, on the one hand, have to be you're aiding and abetting. You're liable for your own conduct in aiding and abetting. That's not you're liable for someone else. But if you can't aid and abet your own conduct, then there's no one can hold you responsible for anything. It's really it's a catch-22.
Well, why can't Gentile be held responsible for his own conduct under the city human rights law, for example?
Well, I would argue that he can. Defense.
But you haven't made that claim yet. But
we haven't made that claim. But I would say that putting that aside, if we're going to focus on the question of what is an aiding and abetting claim, this is the case where an aiding and abetting claim is appropriate, where it's the supervisor who conducts the discrimination, and then that is what the basis of liability is for the employer. So about imputing liability to the employer, it's easy in this case because it was the supervisor and other supervisors that did the other conduct. But for aiding and abetting, Gentile is certainly responsible. If we were to plead it in the alternative, that he was both the employer and responsible as an aiding and abetter,
I'm sorry, which one is it? Is he the employer or is the city the employer? Isn't your theory that the city's the employer, that's why you have an aiding and abetting claim?
Yes, but I would argue that it's really, in many ways, irrelevant, because he certainly is responsible for what he did, whether it's as the employer or as an aider and abetter.
Judge Renwick, are you there?
We may have lost her.
Yes, I am. Thank you, Mr. Shore.
You're still there.
Yes, thank you. Mr. Shah, you have some rebuttal?
Yes, thank you. Thank you, Your Honor. First of all, Councilmember Gentile said that the comment he made about the movements were made out of sincere concern for the stress and discomfort that Mr. Bistrick seemed to be experiencing.
Is that something we can decide on papers? I mean, isn't that really an issue? Wouldn't that be an issue for trial?
Again, I just wanted to get that out there. The important point is, again, context and all of the favorable treatment that was received. These comments really qualify as petty or trivial, and employers are allowed to ask employment-related questions.
Actually, getting to that point, I think I finally really understand what the plaintiff is saying. So the plaintiff is saying, city is the employer. Can there be an aiding and abetting claim with the city as the employer? And the theory is that Gentile is the supervisor.
Well, the aiding and abetting claim doesn't work because there's no evidence that Councilmember Gentile aided and abetted any of the other conduct that was alleged by Bistrick, by the other staff members.
Well, what about the salary, the business with the salary? Who decides salary in the office? Isn't it the supervisor? If he's a supervisor, Gentile?
It's Councilmember Gentile. And
right. I'm sorry. So if the city is the employer and the supervisor the council member is deciding salary, why wouldn't there be an aiding and abetting claim?
Because it's completely circular, Your Honor. Just as Council Member Gentili could not aid and abet himself, he cannot aid and abet a claim against the city that is derivative from the claim against Gentili. That would just be another way of saying he's aiding and abetting himself.
Who do you say is the employer of the plaintiff?
Well, here we're treating the city as the employer, and the direct claim was made against the city, but the city's liability is only derivative. So if the city is going to be, the city can be liable based on Gentili's conduct, and we're saying Gentili aided and abetted the city, then we're just saying that he aided and abetted himself, which Hardwick says isn't even possible. We did address Tomka. Tomka is an ambiguous decision. It's from and it's inconsistent with Hardwick and the Second Department's decision in Medical Express. And there is no good answer that the other side has presented for why they didn't just bring a direct claim of discrimination against Councilmember Gentili. But ultimately,
well, maybe they will. Who knows? Thank you very much. Thank you both.
Thank you, Your Honor.
Anima Group versus Emerald Expositions.
Good afternoon. My name is Dan Zamuro, and I represent the appellants in this matter. I would just like to highlight a few points here.
I imagine what you want to point out to us is that there's rarely a clearer contract with a clearer arbitration provision than this one.
Sure. Absolutely. It's a very broad provision that would encompass all the
claims. And it also
in this
encompasses the AAA. Let me hear from your adversary. Jonathan Cooper?
Yes, Your Honor.
Yes. So this arbitration agreement here, paragraph 18, which your client signed, says that any and all disputes or claims will be resolved in binding arbitration rather than in the court. And it says any and all disputes and claims arising out of or relating in any way to the agreement. Then it goes ahead and it cites to the AAA the arbitration. So I don't understand. That seems like it would apply to any claim in addition to the claim that is raised for the tortious interference.
Okay, a few points on that, Your Honor. Firstly, you can't have an agreement that an arbitration provision that is broader than the underlying agreement in which it's embedded. There's a context for it. This was for an exhibit space contract for a trade show that happened in June of 2017.
Well, then somebody should have thought of that before they signed the agreement where it says arising out of or relating in any way to the agreement.
And we're contending that what happened here was not related to what happened to that contract. This was post-expiration conduct, and it was an intentional tort.
Well, you have the AAA rules, and the AAA rules gives the discretion under these circumstances, it would seem, to the arbitrator. It says the arbitrator shall have the power to rule on his or her own jurisdiction. So it seems like putting the AAA rules in there specifically, you were giving all of those powers to the arbitrator.
Only if it had to do with the underlying agreement, which was with as the trial court held.
I think my colleague has a question.
Counsel, going to that issue. My understanding of the record is that allegedly your client didn't pay for exhibition space, and then the defendant took certain actions with respect to folks who were sharing that space. Can't an argument be made that in fact it's relating, quote, in any way to the dispute being your client allegedly not making the payment owed, and then the defendant attempting to enforce the agreement with respect to payment?
Well, Your Honor, I'm glad you raised that point. To clarify this, and this was kind of alluded to in my papers, let me embellish upon that a bit by an analogy. According to what the defendants' appellants are saying, they were well within their rights to 2.5 years later run my guy over with a car, as long as they scream out the window, hey, you're a deadbeat, you didn't pay, therefore you're still subject to the limited liability
But that's not what happened here. They didn't run your guy over with the car. They just reached out to the other folks who shared the space and say, look, you can't come to the next show because money is owed. How is that an analogous situation?
Because it's an intentional tort. They're both tortious interference and what I just described are both intentional torts, Your Honor.
But so what? The arbitration provision doesn't say that the AAA can't decide that it has jurisdiction to
I understand that, but the Court of Appeals held back in 1980 in ICC Metals that you can't have a contract that governs intentional torts. That's
Well,
just one of my-
I don't think ICC Metals has anything to do with arbitration.
I'm sorry, which judge am I responding to here?
Go ahead. I'm sorry. Go ahead.
You were finishing what you wanted to say. You go ahead, Justice Singh.
What I was saying is that I don't think ICC Metals, I think it was a bailment case, has nothing to do with arbitration.
And no, I was going to say the rules of arbitration have developed far and much more clearly since 1980. And it's very clear when you put the rules in there that you're giving a lot of power to the arbitrator. Anyway, I think Justice Kern had a question.
No, I was just going to say, isn't the law well established that if there's a dispute as to whether or not something should go to an arbitrator and the rules apply, the AAA rules apply, then the arbitrator decides it, not us. So the arbitrator can decide in the first instance whether or not it's subject to arbitration rather than the court, and that's black letter law at this point.
Well, Your Honor, yes and no. The black letter law, I believe, respectfully, is that in the first instance, that jurisdiction resides with the courts, and that once they decide that there is a valid arbitration, that the agreement itself encompasses the arbitration, then it gets flipped. That burden then gets flipped. But I think in the first instance, this court's Mionis decision says, the Pharmacia decision from this court says that in the first instance, that discretion resides with the court rather than with the arbitrator.
Thank you. Mr. DeMuro?
Sure. Yes. With respect to the Pharmacia decision, that had a specific exclusion of certain claims in that arbitration provision, and that was the claim that was trying to be brought and compelled to arbitration. So that case really doesn't apply. I agree with everything that the bench has said with respect to the incorporation of the AAA rules into the arbitration provision. That is black letter law. That it's clear and unmistakable evidence of the party's intent to delegate issues such as arbitrability, such as the scope of the arbitration provision, what claims can be brought pursuant to this arbitration provision to the arbitrator. So regardless, aside from the fact that this is one of the broadest arbitration provisions out there, the scope of it should be decided by the arbitrator.
Thank you. Thank you both.
Your Honor?
Yes.
I just wanted to make one point, if I may.
Do you have a cross appeal?
No.
No, I'm sorry. The time is over. The argument is over. And you actually had extra time. Thank you very much. Velez versus Roy.
Good afternoon, Your Honor. Stephen Toner, representing the defendant appellant from McGivney-Kluger.
Mr. Toner, this is Judge Shulman. You essentially challenged the verdict below in three basic areas. One, that the plaintiff's expert witness went beyond the scope of the 31O&D notice. Two, that the court abused its discretion in allowing the video or the secondary evidence of the video to come in. And third, that the comments made by plaintiff's counsel in response to your summation were prejudicial as to have affected the outcome of the verdict. Is that a fair statement?
Yeah, there were 4 points, Judge Shulman. Like I said, the first one that was presented was the plaintiff's failure to prove conscious pain and suffering based upon the evidence. That it was merely speculative conclusions that should not have gone to the jury. That the expert that they called, Dr. Hua, exceeded the scope of his 3101D.
Well, there's no case law that mandates that every aspect of the proposed testimony has to be spelled out in a 3101D notice. I mean, we were a trial judge. Oh, by the way, did you mark the the notice as a court exhibit so that we had the ability to have it as part of the record to compare what was said in that notice below and what you're arguing in your brief?
I believe so, but I don't have it directly.
I don't think so.
Okay.
I think that came as a supplement, so you didn't do that.
Okay.
Point two, there's no case law that you briefed that mandates that an expert, if he generally says, I'm going to establish in my proposed testimony that there was pain and suffering for the 2 minutes, 1:38 and 1:41 p.m. of that afternoon, based on what I've read in terms of the medical records, the autopsy report, et cetera, et cetera. There's nothing that mandates that he has to spell out his testimony, is there?
Not that mandates that he has to spell out his testimony, but it does require that the experts submit the basis upon which his opinion is premised. Now, in this case, I can tell you in my preparation for this trial, I looked at the original records. The only medical records in this case that were actual medical records were the emergency responders who got to the scene approximately 3 minutes after this accident, who said that the plaintiff's decedent was unresponsive at that time. The only other medical records were when he was brought to the hospital, and they made the similar argument, they made a similar finding that he had no consciousness. The Glasgow score was minimal. He never regained consciousness. He died. So for those were the underlying reasons why I rejected the plaintiff's expert witness disclosure practically a year before this trial, because what he had provided did not provide the requisite specificity of a 3101D that gives me a reasonable understanding of what his testimony will be predicated upon. Because when I go in to try this case, I look at every available medical record, and when he's making a claim for conscious pain and suffering, I want to see if what that's based upon. He had nothing that he...
I'm sorry, counsel, this is Judge Singh. Was Mr. Mejia, was he deposed in this case?
He was not. Was
he interviewed? Was he interviewed by your investigator in this case?
Not by my investigator.
Was he interviewed by any investigator in this case?
He was interviewed by the plaintiff, who then arranged a private phone call. Plaintiff's counsel put together a private conversation between Mr. Mejia and Dr. Hua to discuss Mr. Mejia's observations or his conclusions.
Did you have an opportunity to depose Mr. Mejia? Was he disclosed as a witness?
He was disclosed, yes, he was disclosed as a witness on the accident report.
And wouldn't you think that Mr. Mejia, who, as I understand it, is a certified EMT, first person on the scene, would be someone you would have deposed, and you would have understood that his testimony was that there was a period of time that the decedent was going in and out of consciousness?
Well, first of all, Your Honor, Mr. Mejia was not listed as a witness in the police accident report. The police accident report was very thorough. It contained lengthy statements from the driver of the city tour bus, the other witnesses who were on the scene. These were all the statements contained in the police report. This Mr. Mejia was somebody who was not listed in that report, but apparently came on the scene and gave his name to somebody, and that's why his name was disclosed as a witness. But I had the police investigation, which had all the statements, which had the investigation of the officers, which gave a very clear description of the facts and circumstances of this accident and what occurred immediately before it, with the plaintiff passing cars on the right-hand side and then trying to cut in between the stopped city tour bus and my client, who was braking to stop behind.
But even that statement, is that an accurate statement? Didn't your client admit, in fact, that he hit the accelerator or not the brake? I mean, am I missing something there?
No, several months after the accident, the officer Wilson, the detective Wilson, who was investigating this case, had kept calling him. He said that at the scene when he was interviewed, and consistently maintained that he had his foot on the brake. He was slowing as the plaintiff went through perpendicular in what was estimated as a 7-foot wide space behind the stop bus. Mr. Roy testified at trial that the detective kept calling him and said, just please admit that you did it to give the family some closure. And Mr. Roy said after that long time of Detective Wilson calling him and saying, just admit it, he finally said, yeah, my foot might have slipped off the gas. And after that, he never heard from this Detective Wilson again. But Mr. Roy, at the scene, the statements he gave to the police who were investigating at the scene, and in all the statements that were maintained and created following this, he consistently said his foot was on the brake as he was slowing down. At the time, he was confronted with an emergency situation of this guy passing him on the right when he's focused on the back of the bus that stopped in front of him, and then turning perpendicular. And that's the way the impact is described on the police accident report. It wasn't a matter of pulling into traffic. The motorcycle was perpendicular. It was the width of that motorcycle was described at trial was about 4 feet wide, adding the width of the plaintiff's legs on either side, brought it out to be about 7 feet wide, cutting perpendicular to go through a 7-foot space. The investigation, the witnesses all uniformly said this accident was caused by Mr. Velez passing on the right-hand side and then attempting to make a sharp, quick turn in front of the taxi. So as I said, my client maintained from the get-go, from the scene of the accident, that he was stopping behind a stopped city tour.
Thank you. Thank you. Mr. Shields?
Thank you, judges. Justice Renwick. May it please the court, Elliot Shields of Rolfe and Roth for the respondent, Sorrel Velez, as administrator of the estate of her father, Juan Velez. Your Honors, this is a very simple case, and the defendants weren't deprived of a fair trial. In this case, the jury's verdict was 100% correct, and the damages verdict shows that any allegedly improper or intemperate statements by respondents' counsel and summation were completely harmless. The jury heard all of the evidence and they watched the video, and the trial judge heard all the evidence and watched the video, and they found that Mr. Roy was 100% liable for causing the crash, and that Mr. Velez was conscious and suffered excruciating pain for 1 minute before he died.
How do you respond to your adversary's argument that your 3101D was not sufficiently specific to put him on notice, really, as to what you're claiming with respect to conscious pain and suffering?
As your Honors noted, they did not mark the 3101D notice as a court exhibit at trial, and so that argument was not preserved for appeal. Also, it was plenty. It was very detailed. It was more detailed than it needed to be. It listed that he would rely on the autopsy report, all medical records, all testimony at trial, and all witness testimony, and any other statements that had been given by any witnesses. And
I'm sorry, the video also that you rely on, which you say is very important here, and your adversary notes that it was the original was lost and this was not properly authenticated.
The video, as the trial justice Alpert found, was properly admitted into evidence as secondary evidence. The NYPD, the head of the subpoena litigation unit for the New York City Police Department, submitted a certification which was admitted into evidence as a trial exhibit, showed that the NYPD claimed that they lost the original copy of the video. We requested the video through the Freedom of Information law. They sent us a copy of that on a CD, and we immediately disclosed that to the defendants. They had it for 18 months prior to trial, and Detective Wilson, who we called as a witness only because he had since the time of this accident left the employ of the NYPD and was working for a different police department. So we called him as an expert witness instead of having him come in just as a regular witness. He investigated the incident. He said it was the exact same video that he watched at the NYPD. And under this court's case law, it was sufficiently authenticated under the circumstances of this case.
Thank you.
Sir,
Oh, I'm sorry. Go ahead.
I'm sorry. Very quick. With respect to Mr. Toner's contention that the plaintiff's summation was prejudicial because you accused him of, my words, lying and with respect to his summation, etc. If I'm not mistaken, was there an application at the close of summation or at any time before, during, after the verdict for a mistrial? Was there an application for a curative instruction to address any of that?
There was no application for a mistrial. There was an objection, and the court directed counsel to watch what I was saying, and I followed the court's instructions. And
Okay.
I was just
Did
going to say,
that answer your question, Justice Shulman?
It did. Thank you.
Okay. Any other questions from the bench? Thank you. Did you have something else, sir?
Yes, Your Honor. I'll be very quick. If you take
No, I'm sorry. I was asking Mr. Shields if he had. Were you finished with your thought?
the one last point I wanted to make, Your Honors, was that we lost half the trial. We spent a whole day with the decedent's daughter on the stand describing in detail her loss of guidance and support claim. And the jury obviously wasn't prejudiced by any comments that I made because they gave her 0 for that claim, and they gave her half of what I asked for pre-death conscious pain and suffering damages, which I think $750,000 was consistent with this court's ruling in Oates versus the New York City Transit Authority, but we accepted the reduced verdict to $350,000. So
thank you.
Thank you, Your Honors.
Mr. Toner?
Just very quickly, the Argus video should not have been put into evidence, contrary to what Mr. Shields just indicated to you. When I cross-examined Detective Wilson, he said that he had seen the original some 5 years before, and the original that he saw was clearer than the grainy one that came off the plaintiff's cell phone shown to him in the hallway before he got on the stand. And it wasn't that what was brought in to be shown to the jury was not an identical copy to what the police department had and that Detective Wilson had looked at. And the
counsel, doesn't that go to the weight as opposed to admissibility?
No, Your Honor.
It's not precisely the same. It's grainier. And I assume that you pointed that out to the jury, and weren't they entitled to weigh it in evaluating whether or not there's liability here?
I argued it to the judge, saying it should not come in because it is not a proper foundation for the identification to have this admitted before the jury, and most importantly, especially when timing and my client's time to respond to this emergency situation, which I objected to as well, is during summation, plaintiff's counsel slowed the video down to 1/8 speed to highlight or create a artificial manipulation of the timing of this motorcycle passing on the right and then cutting across. That was improper, that he should not have been allowed to do that, giving the false...
The jury didn't understand that this was slow motion? I mean, you know, we're not dealing with unsophisticated people here.
Your Honor, I didn't get a chance to talk to them to find out what they were.
But isn't it obvious that it's been slowed down to show picture by picture?
Your Honor, what may be obvious in one respect in the context of a trial and evidence being put in front of a jury is going to see something slowed down and may adapt that as being the timing that was actually occurring at the time of this accident.
Thank you. Thank you both. People versus Charles Osborne.
Thank you.
Good afternoon, and may it please the court. My name is Amelia King-Musa, and I represent Appellant Charles Osborne. I will be focusing on the issues concerning Mr. Osborne's plea and sentence for criminal possession of a controlled substance.
I'm sorry, you know what? I skipped a case. I'm sorry, I skipped, just let me go back, okay? Because I skipped one. I'll get back to you. SBL versus PBM.
Yes, thank you, Judge Renwick.
Sorry,
I
you
was
got a
getting
little nervous,
nervous.
I imagine, huh?
Yes.
Sorry about that.
Okay, so this, I feel in this case that the lower court misapplied the standard, Your Honors, in that they gave the defendants a inference that the window washer here, and I represent the young children of the window washer that deceased on the estate, that the window washer here could have cleaned the not only could have cleaned the windows
from the inside and didn't need to go to the outside.
Exactly. So it's a case that
does the affidavit change that at all? The affidavit of the coworker.
The affidavit of the coworker it adds additional information that the plaintiff should not have had to introduce, because I feel that the defendants didn't make out a prima facie case for summary judgment to begin with. But yes, you're absolutely right, Judge Renwick. The affidavit of the window washer, the missing window washer that we were trying to depose for years, he comes in and he says, yeah, of course, the decedent was washing the windows from the outside. We always did that. We were paid by the building. If we didn't get it done quick, we didn't make money. So they would get outside and do them really quick from the outside. That's what the affidavit says.
Should you have had that? Okay. I think you answered that question. Go ahead. I'm sorry.
So I feel, Judge, that even before we get to that affidavit, as I said, I feel that the inferences were not afforded to the plaintiff as the non-movement. The evidence was all over the place that the lower court credited to the defendant, that after the employer of the defendant said that at times they had to stand on windowsills to clean, that that was not even mentioned by the lower court. The lower court seemed to imply, although it was not clear, the lower court seemed to imply that the defendants had made out a case that historically the exterior windows were always cleaned while the window washer was standing on the floor of the interior, because he tried to analogize this to the Bragi case, where there was that evidence in the Bragi case. In the Bragi case,
but counsel, aside from, I think it was Mr. Ventura's affidavit, what evidence is there, in fact, that the decedent was outside the window, or outside on the ledge?
Well, that's my point, Judge Singh. I don't think that the plaintiff had to introduce evidence to prove exactly where he was when he fell to his death.
But then, but you still have to bring it within the parameters of 240 Prens 1, and without Mr. Ventura's statement, how does that come within 240 Prens 1?
Well, I respectfully submit this. We know for a fact that he was subject to a gravity protection risk because he fell to his death, either because he was leaning out the window or because, as the defendants say, he was standing outside the building, which is fine. If the defendant's fact pattern is adopted, Judge Singh, there is a gravity protection risk.
I don't think they're saying he fell. They're saying he was inside.
No, they're saying he was outside. They're saying he was standing.
We'll hear what the defendants say, but I'm not sure.
Justified by your argument. There was a renewal. You have an affidavit which clearly raises, why are you not relying on the affidavit? Because the record, other than the affidavit, is all the work was done on the inside. The supervisor testified the work was from the inside. The building testified the work was from the inside. Until you got that affidavit, all of the testimony was consistently that the cleaning was from the inside. And you got this affidavit, which totally contradicts that. So why are you not wanting to rely on that affidavit to support?
I love the affidavit. You're right, Judge Kernan, and I'm sorry if I didn't accept Judge Renwick's question as positively as I should have. I love the affidavit, and I do feel that the affidavit puts us in a situation where it's flat issue of fact. The motion must be denied, and I do agree with the Judge Renwick.
So I thought your argument would be, wow, this is the perfect renewal motion. We were waiting for this deposition. We never got the deposition. And now we finally found out they're no longer employed, so we could get the affidavit. This is a classic renewal. And Your Honor, give us the renewal and give us the issue of fact.
Yes, it's a classic renewal. I don't know how the lower court said that they're not granting renewal because we didn't try to get the deposition of Juan Carlos Ventura before. The record it's all over the record that we were begging the lower court to give us the deposition.
Let's hear from the respondents, and we'll get back to you. You have 2 minutes. Mr. Shapiro, you're first.
Good afternoon. May it please the court, Sim Shapiro on behalf of the defendant, respondent, PBM. The issue here is under Bragi and under Soto. Sorry, I'm hearing some feedback.
Yes. Ms. Bedell, you have thank you. Go ahead.
I beg your pardon. The issue here under Bragi and Soto, both of which are cited in our brief, is the condition, did it necessarily create an elevation-related risk? Not was the decedent working from a height, is whether the work required him to do so.
Well, okay, counsel, let me stop. Go ahead.
Go ahead.
Let's start with the renewal, okay? Assuming that there's a basis for renewal, does the Ventura affidavit raise an issue of fact as to whether or not there can be labor law liability here?
It does not. And one of the things I need to clarify, if you look at the affidavit, the witness there in paragraph 3 of his affidavit does not say they were working outside. In fact, he says just the opposite. He says they were working on the sills. This is, by the way, on page 2258 of the record. He says they were working on the sills and leaning outside. They were not working on outside. No one has said that. He didn't say that. And again, the issue here is, did the work require them to do so? And they would have to have evidence, and this is straight out of Bragi and Soto. They would have to have evidence showing that the equipment that this decedent received wasn't sufficient, and that's a burden on the plaintiff. It is not on the defendant.
Counsel,
Again,
why isn't the testimony of the worker in the affidavit, if we accept that testimony, that was how they're required to do their work, to go in the sill, which raised the risk of falling out, and it did in fact fall out, why wouldn't that version require a safety device to protect against that occurring?
Because he doesn't say that. And I'll read straight from the quote from the affidavit. He said, while I was working at 345 Park Avenue South, Rengifo stopped by to check us, and he was present during, I'm sorry, I'm reading the next paragraph, paragraph 4, I beg your pardon.
Why don't you start at paragraph 3?
Yes, paragraph 3. We would watch the outside surface of the windows by standing on the windowsills and leaning outside of the building.
Okay, so let me stop you there. Leaning outside the building. This is how many floors up? 4 floors up there?
4 floors up.
So if you're leaning outside the building, you don't think that becomes an elevation risk?
Because the issue isn't were they doing it, the issue is were they required to do it. And you'll notice in his affidavit, he doesn't say they were required to do it. And there's testimony from Mr. Rengifo, the employer, explicitly that you could stand on the ground.
4, I'm sorry, and I apologize. Paragraph 4, this was the approved method.
Right. That, again, obviously, I don't think you should be considering that affidavit, but even if it's approved, that's not the
it's the elephant in the room. I'm sorry, counsel.
Right, absolutely. That's
Let's
not
get
the
to Ms.
standard,
Bedell.
The standard, if I could just finish the sentence though, the standard is, did the work require it? And there's testimony unrefuted from Mr. Rengifo that you could use a pole and reach the very top. No one has disputed that. This witness who came in at the end doesn't say I had to do this. He just said that's what we did.
Thank you, Ms. Bedell. Just unmute yourself now. Go ahead.
apologize, was having some technical issues while the rest of the argument was occurring. I do know that we were talking about the affidavit, however. A couple of things, which I think may have already been addressed. The affidavit from 2013 addresses what the procedure may have been like if we take it as true and we disregard the other issues with the affidavit. The testimony close in time to the accident is that these instructions were given repeatedly. Number two, when we read the third paragraph, where Mr. Ventura is presuming that the decedent was leaning outside the window while standing on the ledge, that necessarily presumes that he fell through the window, okay, versus from the ledge. Now, the initial motion practice, plaintiff claimed repeatedly that the decedent fell from the ledge and that he wasn't provided protection from the ledge. And the OSHA investigation concluded that he fell from the ledge as well. So, and most importantly, the implication from the affidavit is that he fell through the window, like I said. However, all of the evidence and the plaintiff stated throughout his motion papers was that the window was closed when the incident occurred. When the police were there, when OSHA was there, when Lisa Akampora was there with the police, when
But doesn't that go to the weight as to, you're asking us in essence to weigh the affidavit, right, of Ventura against the other evidence suggesting that the window was closed?
No, Your Honor,
I don't follow that.
My argument is that based on all of the evidence that we have, the affidavit is incredible as a matter of law, because we have an incident report from plaintiff's initial motion papers where the security guard says the window was closed. We have Lisa Akampora with the police officers observing personally that the window was closed. Mr.
Well, if the window was closed, how did the decedent end up on the ground?
Well, as plaintiff argued in the initial motion papers, he climbed out, and the OSHA investigators show he climbed out onto the ledge and he fell. The window, since it was closed, he was cleaning the window from outside on the ledge. Therefore, when Mr. Ventura states that he was leaning out, it couldn't have happened that way because the window was closed.
But
thank you.
Well, but Ventura also says that it was common practice for workers to wash windows from the outside, and this was encouraged by the boss, cleaning from the outside if the workers were willing to do so.
Well, even so, first, that was in 2013. And number two, all of the testimony shows that these windows tilted in. It wasn't necessary to go out onto the ledge. And GEO only performed interior window cleaning on tilt-in windows, and it farmed out work on the exterior.
I think also mean, by the way, the window being closed is that when he flipped out from the inside out, the force of him flipping out closed the window. Since the window was in, it would have just swung back out. Anyway, I think we understand.
Your Honor, may I just one more? I would just submit that that would be speculative, Your Honor. Thank you.
I guess so would that he was on the ledge when he was cleaning it, right? Because no one saw him before he fell.
Well, five police.
The window was closed, but we don't know that it was because he was on the sill cleaning. That would be speculative also. Mr. Bastani, back to you.
Thank you, Judge. I just wanted to make 3 points. The first point Judge Singh just made for me, but I just want to revisit it, that paragraphs 7 and 8 of the Ventura affidavit do say that the defendant was aware that the plaintiff's father would be cleaning from the outside ledge. So that is covered by the affidavit as well, although counsel didn't read from those sections. The other 2 points I wanted to make was that the defendant himself would remind, according to the papers on record pages 289, 384, and 385, the defendant himself would remind the plaintiff father not to go out and clean from the outside, which establishes that the defendant was aware that when they gave this job to the decedent, there was a likelihood, or at least it would be foreseeable, that the defendant would go, that the plaintiff's father would go out and clean from the outside, at least for those windows that Marangifo, the supervisor, said would be stuck. He testified that a lot of times the windows would be stuck, or there would be things in front of the windows, and leading to the foreseeable condition where the window washer would have to go outside onto the ledge to clean. So the defendant himself admits that I reminded him every day not to do that. So that turns that into a instruction not to do something, which would not be enough to make him the sole proximate cause of the accident. And the final point I wanted to make was under Section 200 of the labor law, the defendant's and the lower court's view of the law is incorrect. And this court has time and time again, including most recently last year in Bianca, said that the ability of a defendant to supervise a worker is what controls.
And how did the building defendants have a ability to supervise or control decedent's work?
The contracts that they were so voluminous, but I attempted to quote a portion of them. The contracts required the defendant to supervise the defendant and the window washers and use and put up scaffolding. So that was not addressed by the defendant. So we argued, Judge, saying that because they had that duty and they had the ability to supervise the plaintiff, the fact that they argued in their papers that no, they didn't even show up, they didn't supervise the plaintiff, they could care less, that's not enough to take it out of 200. That's all I have if there's no further questions.
Thank you. Thank you both. Thank you all. Next one is People versus Charles Osborne.
Good afternoon again, Your Honors. My name is Amelia King-Musa, and I represent Appellant Charles Osborne. I'll be focusing on the issues concerning Mr. Osborne's plea and sentence for criminal possession of a controlled substance. Now, importantly, respondent has conceded that Mr. Osborne should have been sentenced under the 2009 DLRA. The question that remains is, what is the appropriate remedy? And
well, I think they say it wasn't preserved, that he should have been sentenced under DLRA, but it wasn't preserved, so he shouldn't apply. So I think you have to speak to preservation first.
Absolutely. And the court's error in imposing this illegal sentence did not require preservation. The illegal sentence exception to the preservation rule applies in this case. And the Court of Appeals in People v. Reynolds has acknowledged that the illegal sentence exception can apply in the plea vacature context as well. And that's precisely the situation right here. And now the plea vacature is the most appropriate and efficient.
Why shouldn't there just be resentencing now? If the issue is that the wrong sentence is imposed, why would that create an independent basis to withdraw the plea rather than to just have resentencing?
Sure. A few points on that, Your Honor. First is that, the court had an ongoing due process obligation to make sure that the sentence was legal and legislatively authorized.
But now, when the plea was taken, the sentence that was discussed was legal. So the plea itself wouldn't be vacated, would it, under those circumstances? The law didn't change till several years later, 5, 7, whatever, many years later. At the time he absconded, at the time he had the plea, and the time they discussed those plea negotiations and discussed the sentence, that was legal.
Yes, and then by the time that he was sentenced, that sentencing scheme had been completely legislatively repudiated. And just to the point about resentencing as a remedy, in this case, any resentencing would inevitably lead to plea withdrawal, given the Court of Appeals decision in People v. K2. A current legal sentence for fifth-degree criminal possession necessarily includes a period of post-release supervision. Now, Mr. Osborne,
given the period and given I think the sentence, the new sentence under the DLRA is it 1 to 2, anywhere between 1 and 2? Is that it?
I believe it is 1.5 to 4 with mandatory post-release supervision of 1 to 2. Yes, Your Honor.
1.5. So he could, it would not be different, a completely different expectation than to what he was originally sentenced to.
Except that Mr. Osborne never had any sentencing expectation of any period of post-release supervision. And that's an important part of the calculation of whether or not to plead guilty to a certain case. So if this was remanded for resentencing, necessarily the court would have to allow Mr. Osborne the opportunity to withdraw his plea, as he never had an expectation or knowledge of post-release supervision, and that would necessarily be part of his new sentence. Now, since any resentencing would necessarily lead to plea vacature, the most efficient use of time and judicial resources would simply be to vacate Mr. Osborne's plea now.
So counsel, don't you have a stronger argument on this issue with respect to the bail jumping?
I think it's equally strong, Your Honor. Now, Mr. Osborne's plea to bail jumping is so enmeshed in this mistake of law that it infected that plea there, absolutely. But as I said, the sentencing court still had a due process obligation to ensure that the sentence they were imposing was legal. And so this mistake of law has really infected both of his pleas. And for that reason, I ask that both of his pleas be vacated.
Thank you. Ms. Nielsen.
May it please the court, Claire Nielsen for the people. Your Honors, defendant's pleas should be left intact.
So counsel is saying that, he originally was sentenced to 2 to 4, but now, given the DRLA, it'll be 1.5 to 4, a definitive sentence, somewhere between 1.5 to 4. But then there's this PRS. So would the court not be able to fashion a term within the original expectation?
No,
sorry. Yeah, so that he could have 1.5 and 1 year. I mean, or would that change if the court could sentence to whatever the court wanted? Would that be beyond what his expectation was initially?
No, I think it's very reasonable. It's within his expectations that he had at the time of the plea.
But he didn't have an expectation to get out of jail and then have to report for X number of years. Does that make a difference?
I don't think so. And I know defense counsel mentioned People v. K2, but the K2 case is dissimilar from the issues here. In K2, the issue was at the time of the plea was agreed to, defendant wasn't informed of the PRS term. However, here the issue was, since the plea was in 2002, PRS wasn't even a mandated provision at that time. So there was no way that the court could have predicted that defendant would abscond and then the law would change several years later. So the court could reasonably impose a sentence within its expectations, like 2 and 2, and that would be the best outcome here under the circumstances. As I said, because PRS wasn't part of sentences when he was sentenced under the drug plea.
What about the bail jumping?
On the bail jump, first of all, defendant was greatly benefiting from the reduced charge from the first-degree charge, and his sentencing.
But the court was under the impression that it was required to impose consecutive sentences. Was that accurate?
No, the sentencing court did overstate the extent to which the 2 sentences had to run consecutively, and that confusion was again engendered by defendant's conduct because the laws had changed several times. Statutes that used to run.
Did any of the parties, did the prosecution attempt to correct the judge to say that it didn't have to be consecutive? Wasn't it the fact that everyone believed it had to be consecutive?
No, the court did acknowledge that concurrent sentences were a possibility. It wasn't just categorically, we have to impose consecutive sentences here. The court did consider defendant's past drug addiction in trying to determine if concurrent sentences would be appropriate here, but they decided that would not be the case given the bail jumping crime, given defendant's conduct, given the length of time that had passed over these 15 years that he had absconded. And I think it's most important to note that the people who were dropping the top count on the first degree count, they did not feel that concurrent sentences were appropriate here, and they conditioned their plea agreement on consecutive sentences. Defendant was aware of that, and he agreed to that plea agreement.
Thank you. Is there something else?
No, if you have no further questions, we ask that the court uphold the pleas. Thank you.
Back to you, Ms. Musa.
Thank you, Your Honor. I'd simply like to address the resentencing argument one more time. Now, Mr. Osborne believed he was avoiding much greater risk than he actually was by accepting that bail jumping plea. And excuse me, I'm so sorry. Going back to the criminal possession count, again, he had no expectation ever at the plea or his sentencing about any period of post-release supervision. This is a great factor in determining whether or not to plead guilty in a certain case. So if this was resentenced, People v. K2 would apply, and he would necessarily have to be given the option to withdraw his plea. Since any resentencing would necessarily lead to plea withdrawal, I ask that the court vacate Mr. Osborne's plea here.
Thank you.
Thank you.
Thank you both. Cuddy Law Firm versus NYC DOE. Mr. Kopp.
Good afternoon, Your Honors. Essentially, what we're looking at here is that the Department of Education and through the Law Department of New York City have not really shown any evidence for why any of these records should have been withheld in the first place. And when the decision came out in the Article 78 court below, the decision essentially regurgitated a lot of the conclusions that were being made by the city in this matter. And some of the instances that could be seen here are that, for instance, the evidence that was provided by the petitioners included some of the documents that had started to be given post Article 78 commencement to the court, and showed that not just law firms, but solo practitioners were listed among some of the cases that the DOE was providing through the FOIL request. But at the same time, the court came back and said in the decision that individual attorneys' names, along with the IHO numbers, all of that would be prohibited under FERPA, essentially going against what the city was saying to begin with. And this really went over to several of the other categories of information and documents that were not being provided under the FOIL request. The summary sheets and timesheets, for instance, these were all, as the court's well aware, these were centrally located, and this was evidence provided to the Article 78 court. And there was no evidence, no showing, no discussion of what it would take to go into the emails from that email account where those were stored and to essentially bring the attachment out of an email, put them all into one folder, print those out, redact them, and then send them over to the law firm.
So counsel, your issue is that there should be a hearing on whether or not it's burdensome, or what? I mean, what exactly are you asking us to do here on this issue?
We would be asking the court for one to remand to the Article 78 court so that there can be
a hearing on whether or not it's burdensome.
We don't believe that there would need to be a further hearing on it at this point. We believe that there should be an order to say that these need to be produced at this point.
On what grounds? If in fact it is burdensome, why shouldn't the Article 78 court make that determination in the first instance?
The court had the opportunity, and the city had its opportunity to show that there was burden, but the city never met its burden of proof.
Okay.
The city came back and said, well, we just want to point to the language of the statute, which then points to the language of another statute and another statute. But then nobody ever said.
Isn't there a dispute, though, as to whether or not it'd be burdensome based on the evidence that the city has presented, that it's in different locations and different ways to get it? Doesn't that raise, at a minimum, a fact?
Yes, Justice Kern, and that's one reason why we brought in evidence afterward in our reply papers to show the Article 78 court that no, this isn't really being in several different offices. These were centrally located in a single email account. And that's where there was still an opportunity during oral argument that the DOE and the city may have come back and said that, well, here are the exact locations of where all of these are stored outside of this email account. Here's where we put them after these documents are given to us. And they didn't do any of that.
Sir, I'm sorry, this is Judge Schulman. Wasn't there an issue below with respect to putting aside the issue of burdensomeness, whether your request could potentially reveal the identity of students, which is privileged? Isn't that one issue? And the second issue is your second FOIL request, because you made two of them, is still in the works, so to speak. There's been no exhaustion of administrative remedies. Would you agree with that, sir?
No, Your Honor. To the first issue, the several courts have found, listed through the brief, have said that it needs to be shown how there's going to be a link to personally identifiable information. And so, at least in a way, tracking how saying what's essentially an administrative case number is then going to link to particular people who are then going to link to a student's name and the information that is not supposed to be released. Here, the only information that could have potentially been there is the law firm that was representing the student. Of course, they can't give that information away because they have their own ethical obligations of confidentiality, and the hearing officers, who are also all still attorneys, and they're effectively judicial officers at the administrative level.
Thank you. Mr. Paulson? I'm sorry, Ms. Paulson, Susan Paulson?
Good afternoon, Your Honors. May it please the court, Susan Paulson on behalf of the New York City Department of Education. Your Honors, the plaintiff here filed a FOIL request for 2.5 years of records that were not centrally located. If you look in the record on page 299, that email address went into effect in June of 2017, and the FOIL request began in January of 2016. Now, the FOIL request asked for attorney's fees information about IDEA cases, but not just the amount of attorney's fees paid. The requests were the names of the attorneys and the paralegals seeking the fees, the rate at which they billed their time, the hours billed per person with subtotals for attorneys and paralegals, an itemization of expenses, a subtotal and total amounts billed by type of charge, settlement agreements, summary sheets. The Department of Ed is not in the business of maintaining this information in this format. Absolutely, they can search their records and find it. It would be as if somebody asked the court to look for, in IDEA cases, how many of them filed motions to extend time, tried to slow walk appeals, how many of them were based on certain reasons for motions. Certainly the court could find this information, could aggregate it. The Department of Education explained 3 times, if you look in the record on page 50, on pages 74 to 76, and on pages 164, that this information was not centrally stored or consistently tracked. that some of this information was embedded in other documents that they had to search.
Counsel, this is Judge Kern. Why couldn't they have produced the stuff that was centrally located and refused to produce the documents that were not centrally located? What was the basis for a wholesale refusal to produce any?
Yes, Your Honor, there was no wholesale refusals. To the contrary, they produced a 79-page spreadsheet with thousands of records. There was no wholesale.
Counsel, that's not the question I'm asking. I'm sorry. I thought your position is that some of the documents were centrally located, but some were not.
Yes.
Why couldn't there have been a production of the documents that were centrally located in addition to the spreadsheet?
Yes, Your Honor, from the documents that were centrally located, as well as from the documents that were not, the department culled certain information that it was able to produce. There was no wholesale distinction between the centrally stored and the not centrally stored. They were looking at both, all of the information that came into that email address that started in June 2017, as well as the information from cases starting from the beginning of the FOIL request. From that, they produced a 79-page spreadsheet with 3,505 case records that they included certain information.
I'm just going to interrupt for a minute because you keep mentioning the spreadsheet, but where in the FOIL law does it say if you have the documents, you can produce a spreadsheet and not the document, and that's sufficient if the documents are not unduly burdensome to obtain?
Well, the plaintiff at some point said it could be produced in spreadsheet format. So the department largely produced the information or produced a large amount of information in response, and there was certain information that the department withheld. It withheld the IHO and 10-day case numbers because of a risk that it would, in combination with other information, could lead to the identification of students. Now, the department is under an obligation under federal law, under FERPA, to be particularly cautious about information that can lead to the identification of students at the risk of losing federal funding. Now, this information, the IHO numbers and the case numbers, can disclose the case materials that can reveal to, in combination with other information, the identity of the student at issue in that case. They properly withheld that information under that. Counsel conflated the fact that the individual attorney and paralegal names were also withheld, but that was not under the privacy exemption. That was withheld because it was unduly burdensome, because the way in which it was tracked in the DoD database was under the law firm or solo practitioner, as it may have been, but not under the individual attorney and paralegal names. It was under the essentially the payee, who wound up being the firm or the solo practitioner. It was unduly burdensome to manually go through those and find out who the individual attorney and paralegal names were. That was not under the privacy. That was under the other exemption.
Thank you. Mr. Kopp? You're muted, Mr. Kopp.
Sorry, Your Honor.
Okay.
Just briefly to address the other point that Justice Schulman had made before we went to Ms. Paulson. Even though the DOE had not begun to address the IEE FOIL request, these were being treated as one FOIL request sent separately, and the DOE essentially acknowledged that it had this IEE request on July 13th without sending anything to our office. Their acknowledgement came up in the Article 78 court, and then we sent it again when we did the appeal. So if the DOE wanted to show that it had acknowledged all of this was still under review, it should have done that when we made our administrative appeal, and they failed to do so in the public officers law, so that's an automatic constructive denial.
Thank you.
Yes, Your Honor.
Margulies, thank you both, by the way. Margulies versus USAA Casualty Insurance.
Good afternoon. My name is Alex Klein. I represent Joshua Margulies. May it please the court. Our view of this case rests on a simple proposition. First, all parties will acknowledge that in the case of a breach of a contract, one of the remedies available are reasonably foreseeable consequential damages. Next, there have been 3 courts, not including the court below here, that have all held that USAA breached its duty to defend Mr. Margulies, which is a creature of contract.
You seem to be asking for indemnification as well as defense costs here.
We are not. We are asking for strictly consequential damages. We acknowledge that the question of indemnification is gone. We're not seeking it.
Okay.
If there's any doubt that we are asking for it, I will tell you we are not seeking indemnification at all.
Good. So you're not seeking for them to pay $4 million.
I'm sorry?
You're not seeking their payment of $4 million.
What we're seeking are what is reasonably foreseeable consequences of the breach of the duty to defend. And there will be defenses that USAA can raise as to whether the full extent or a portion of the judgment that was entered against our client was not.
Isn't that just another way of seeking the indemnification? I mean, isn't that just going in the back door? Defense costs means the cost, attorney's fees, exhibits, costs related to the defense. And I think that the Mr. Margulies was pro se for some time, and then obviously you're retained. Those would be defense costs, but I'm not sure I see costs beyond that.
It's not the same, and the reason why is because of the scope of the damages. In this case, what we had here was a victim, Mr. Hoff, who was hit by a slow-moving car. It was moving so slowly, in fact, that he backed into it.
I don't have any doubt that $4 million was beyond the amount of the damages, but there was a default, it wasn't vacated, and nobody appealed it.
Right.
So that stands, right?
Right, and so the question is, what percentage of that judgment is a consequence of the failure of the duty to defend? And it's not a question of indemnification. Indemnification would be us saying, USAA is responsible.
You're saying because they didn't show up, they defaulted. In addition to Mr. Margulies defaulting, they defaulted themselves by not appearing.
Yes, USAA had a duty to defend our client. The question, and they breached that duty. 3 courts have noted that, and as well as the court below. So the question is simply, what were the reasonably foreseeable consequences of that default? Our client is notified of the existence of this case after a $4 million judgment has been entered against him. The basis.
Your client was never served with the underlying summons and complaint?
He was not. He sought to vacate the default judgment. He lost that, but he did not receive a copy of the summons and complaint until after there was a judgment entered against him. At the time, he was dealing with his terminally ill son. He was living in North Carolina for some special treatment that his son Benji was receiving. Ultimately, Benji passed away when he was 3. And so during this smoke surrounding what was happening with his family, he was being served with papers back at his apartment in Manhattan, and didn't learn of any of this until after his son had gone through this experience. The basis of USAA's counter to the question of whether these were reasonably foreseeable damages are these 2 cases, Servodone and K2. Neither of those cases, however, deal with consequential damages. They don't mention the term consequential damages. But Judge Renwick, to address your question, whether this is really just a backdoor way of getting to indemnification, it's not, because indemnification is a creature of contract that we would be standing here saying we think that we are entitled to the full value of the default judgment. What we would like the opportunity to do, and again, this is not we are right or they are right on the facts. We're just seeking the opportunity to have discovery and deal with the question whether a portion of this default judgment was a consequence of the breached duty to defend, as opposed to a consequence of something that would have happened anyway. So, for instance, there have been several courts to look at this case that have held.
I understand your argument.
Okay.
Is there another one you want to make, or do you want to? You can finish up. I'm sorry, I shouldn't. Well, go ahead. I threw you off.
By economy market is a Court of Appeals case that's been cited over 200 times. The idea that consequential damages do not apply to insurance companies in this context beyond attorney's fees and disbursements would be an extraordinary limitation on the holding. And I take it from USAA that they believe that this was done or reinforced through the K2 case decided in 2014, except K2 doesn't mention by economy market at all. The question on whether you can enlarge the scope of a policy based upon consequential damages, well, that's what consequential damages are. In the Pan-Asia case, there was an exclusion in the policy that said you cannot get consequential damages. And the Court of Appeals said that doesn't matter because consequential damages are a creature of a pseudo-tort law that says whatever is reasonably foreseeable is recoverable. The same thing happened in by economy market. That was a case in which an insurance company breached its duties to a client for business interruption coverage. And there came a business interruption that wasn't covered, and the business was killed. And they were recovered not only the value of what the insurance policy would have equaled, but consequential damages above and beyond the policy for the value of what the business was worth. This is what—
Thank you. You have time to respond. Let me hear from Mr. Imbrogno. Now, you have a cross appeal that is part and parcel of this argument, so just answer that within your 5 minutes.
Sure. I think the most important part is it's now $4 or $8 million, which I think everyone concedes would have been better had that judgment not been entered, but it's not something that my client is responsible for. We indicated in the brief that the law of New York has been consistent that if there is a breach of a duty to defend, but there is no coverage under the policy, the remedy is limited to the defense costs, the cost of defending the case. And even that remedy doesn't extend to the cost of establishing that remedy. That's clearly been the law. It's been the law of Servodone, Sucrest, and it has been affirmed by K2-2. And that has been the law in New York forever. The by economy case, we indicated in our brief that the cases that have allowed consequential damages do not include cases that are liability insurance policies. And the reason they don't is because, again, there is a long-standing line of cases in New York that the remedy is limited to the defense costs. If there was coverage, it would be different. They admit that there's coverage. But there isn't coverage, rather. What they're basically saying, they can recover more if there's no coverage than if there had been coverage. It's just not the law in New York. K2-2 so holds. What they're really asking you to do is to change the law contrary to what has been determined by the New York Court of Appeals. Other than that, the only issue that we would have on the duty to defend, there's some question as to whether there should be a duty to defend on the facts here, because the allegations were that this was intentionally injurious conduct, and the fact that
wasn't the only allegation, right, counsel? I mean, it was a little broader than that.
Well, they allege recklessness and negligence, but those are basically shotgun allegations. They're not claiming that there was, some intentional injury, but there was also reckless or negligence. They're claiming they allege that in order to try to get the duty to defend. But the more important issue, because the duty to defend is relatively small in this case, the real issue is the attempt to go beyond K2-2 and Sucrest and Servodone and create a new form of remedy, which the Court of Appeals refused to do. And there's no reason why this court should.
Thank you, Mr. Klein.
Thank you. There has never been a case in the history of the state of New York that has held that the rule of Servodone and K2 applies to consequential damages. There is strictly a rule that says that consequential damages are recoverable to the extent that they are reasonably foreseeable. All we are asking for is the opportunity to present to a court or to a jury that a portion of this judgment was a reasonably foreseeable consequence of the breach. At its heart, what are contract damages? Contract damages are designed to put a person or a business in the position they would have occupied had a contract been performed. If this contract had been performed, I think all parties would acknowledge that Mr. Margulies would be better off than just given some attorney's fees and some disbursements. He would have been provided with a defense. Now, what is that defense? What would that defense have been worth in this judgment? I don't know. I ask that we find out. But what I do know is that that defense is not worth zero. But that's what USAA is asking the court to accept, that there is a loophole in the doctrine of consequential damages that accepts insurance companies from having to pay them so that the value of a defense is deemed to be zero in the final analysis. We would respectfully request that that view of the law be rejected, that the trial court's order be reversed. Thank you.
Thank you. Mr. Imbrogno, do you have anything further?
No, I will just repeat again that there's.
You don't have to repeat if you don't want to.
No, I'm just saying that there's a long-standing line of cases that says when it comes to liability insurance policies, if there's a breach of a duty to defend, but no coverage, the remedy at most is defense costs. That is what the court said in K22. They did not go into by economy or anything else because that has been the long-standing law in New York, and this would require this court to overrule the Court of Appeals. That's all.
Thank you both, Mr. Imbrogno and Mr. Klein. Thank you.
Thanks.
156 10th Avenue versus New York State Liquor.
Yes, good afternoon. May it please the court. I am Francis Buscemi for the petitioner. The main issue presented in this case is whether it's proper for the Liquor Authority to go beyond the record of the adjudicatory hearing to make a finding of fact about the intent of the licensee's principal, Ms. Shen. I believe the Liquor Authority hedges a bit in its brief, but it basically admits that it has gone beyond the record. And the Liquor Authority argues in its brief that's entitled to go beyond the record to determine intent. At page 24 of its brief, it states, nor would it be surprising to find the members of the authority's board considering the available evidence, whether from the ALJ's hearing decision or otherwise, to assess whether there was an intentional violation and thus whether cancellation would be proper. Now, the administrative law judge in this case made no finding of intentional wrongdoing on Ms. Sheen's part. She found that the rule required that the work history be reported, that ultimately, regardless of whether Ms. Sheen had a representative handling the application or not, that ultimately the accuracy of that application was Ms. Shen's responsibility. The administrative law judge also made reference to possible mitigating factors in this particular case concerning penalty. The full board transcript of the full board meeting of June 10th, you can review it and see the counsel to the Liquor Authority, the head prosecutor for the Liquor Authority, discussing with the chairman and other members 3 or 4 other cases unrelated to the petitioner's case. These cases were against other licensees, notices of pleading against other licensees, which involved Ms. Shen's husband, but not Ms. Shen. None of the notices of pleading in those other cases reference the petitioner in any way.
Counsel, this is Judge Singh. In this application, isn't it correct or fair to say that in fact Ms. Shen did submit false information with respect to, her employment at the various liquor stores?
Well, the question I don't think is whether.
So the point being,
yes, it was incomplete. I'll say yes, it was incomplete. If you want to call it a misrepresentation, the question is, was it intentional? And you cannot find intentional wrongdoing, nor did the administrative law judge, Justice Singh, from the record of this administrative proceeding. The
So
liquor
in other words,
authority,
even if the application has incorrect or false information on it, one can't infer that in fact that Ms. Shen intentionally misrepresented her employment status.
I don't believe so, Justice. This court, not that long ago, in Platinum Pleasures, and there have been other cases that I cite in our brief, but take an example of a Platinum Pleasures case. There was allegations of availing, permitting someone in to avail themselves of the licensee's license. There were applications that weren't even filed, unauthorized alterations. There were financial matters which weren't disclosed by the licensee. And this court found that, overturned the liquor authority's determination of cancellation, and found that without deliberate and intentional wrongdoing, that cancellation is not an appropriate penalty. So I think it's more than just inferring, well, if you didn't list all the information, that you must have intended to deceive. And that's not what the liquor authority did here. The liquor authority, as you can see from the answer of the liquor authority in its answer first put in all these exhibits from these other cases, which have nothing to do with the petitioner's case, other than that they involve the petitioner's husband. They put in hundreds of pages of documentation from those cases, along with numerous allegations in their answer concerning intent. And they were gleaning this intent from these other cases that Ms. Shen was not involved with. They could have conducted the hearing in a way that perhaps would have shown some ill intent of Ms. Shen, but they didn't do that. They called one witness. That witness didn't talk in terms of intentional wrongdoing. They didn't try to get into evidence any of these documents.
Thank you.
That are in the answer.
You have, yes, thank you.
Yes.
You don't actually have rebuttal. Do you have anything else?
Just that the petitioner relies on the Simpson versus Walensky case, where the Court of Appeals was very clear that administrative agency cannot make a decision of an adjudicatory nature based on evidence or information outside the record. And that's exactly what the liquor authority has done.
Thank you. Mr. Armstrong?
Yes, good afternoon. May it please the court, Stephen Armstrong on behalf of Respondent, New York State Liquor Authority. First, on the issue of intent, the SLA Rule 53.1b, which is the rule at issue here, false material statements in a license application, by its own plain language does not require intent or willfulness. That's how this court interpreted it in a matter of Platinum Pleasures case from 2015. In that case, the court sustained a 53.1b violation, despite the administrative law judge in that case specifically finding that the misrepresentations were the result of negligence or ignorance of the law rather than any intent to deceive. In this matter, the administrative law judge did not reach the issue of intent in sustaining 2 counts of 53.1b violations for the 2 liquor stores that petitioner did not disclose on her application. This decision was consistent with Platinum Pleasures, which again found that intent was not an element of a 53.1b violation. Now, subsequently, at the June 10, 2020 full board meeting that Mr. Buscemi referred to, the board adopted the findings of the ALJ in her decision as to liability for the charge. But on the issue of the appropriate penalty, the authority's chairman stated on the record that he believed cancellation of the license was the appropriate penalty, that he believed based on the record that petitioner had deliberately withheld this information from the authority in the application. And also on the record at the meeting, the authority's general counsel pointed out that the two stores that were not disclosed on the application, Wine Story and Bonavinos, were the same stores that had recently paid fines of $100,000 and $110,000 for allowing petitioner's husband to avail their licenses. And after this was pointed out, the members voted unanimously to impose cancellation of the license. Now, we acknowledge that these the two cases regarding the other two liquor stores were not part of the hearing record. Even if they had been offered into evidence by the authority, they very likely would not have been admitted. They're really only relevant to the issue of intent, which, again, under Platinum Pleasures is not an element of the offense before the administrative law judge. Now, the board routinely considers things like adverse disciplinary history when determining penalties, and that adverse history is rarely, if ever, rarely, if ever, part of the hearing record itself. Now, the cases and settlement offers involving the two stores that petitioner worked at and failed to disclose were part of the public record. They were considered by the members at prior board meetings, which were broadcast live on the internet. The recordings of those meetings are available to the general public on the SLA's website. So it was not an instance of the board relying on confidential or non-public information to reach its determination. These were publicly available documents concerning potential motive for the petitioner to not disclose her prior employment on her application.
Thank you. But did you have something? Did you want to wrap up with something?
Yeah. If there are no questions, I will leave it there. Thank you.
Okay. Thank you. Thank you both.
Thank you.
80 P2L versus LLC versus U.S. Bank.
Thank you, Your Honor. May it please the court, Rajan Patel on behalf of the appellant U.S. Bank. Essentially, what this case boils down to is whether or not U.S. Bank's mortgage was entitled to be recorded when it was physically recorded in the New York City Register's office back in 2005.
Mr. Patel, there's a form here, the deed, that has no stamp of a notary. Was it in the proper form to be recorded to put people on notice that it was actual a document that was acknowledged?
Yes, Your Honor. The ink original was. The issue in this case is that the digital rendition of the ink original.
So I understand the bank has a copy with a notary stamp on it.
Yes.
And I read the report of the expert, which seems to be speculative and conclusive, in that it doesn't explain, and the tests it does are only to the notary stamp itself. I don't understand how this document going through the scanner would only eliminate the stamp and nothing else, and eliminate it to the point where it's actually, there's not even a speck from it.
Your Honor, I believe the expert report did explain that it's a
no,
density.
It's explained that it was noise, but it only did the test the 3 separate times on the notary stamp, not on the entire page. So the notary stamp disappeared, but a document goes through a machine, the entire document, not just the stamp. So I'm at a loss as to how this document that had the notary stamp on it, only the notary stamp is missing and not any of the other ink, not any of the other typewritten parts. And there were aspects of the notary stamp, on the original at least, that are as dark as the other writing. How did that disappear?
Your Honor, all I can say is that it's a digital scanning issue because, but Your Honor, if I may, we didn't wholeheartedly rely on the expert report to support our proof. We have the ink original document. We submitted a chain of custody that recounted.
Except doesn't that call up the credibility of all of these affidavits? If you have, you present this ink original and all of these affidavits that follow from it, But the ultimate place that this document was supposed to be acknowledged at the at the Department of Buildings or wherever to register it, it's absent. I mean, it just doesn't make any sense. There's nothing, you can have all of the affidavits you want saying whatever you want about a document. The document, yes, it has the stamp. I don't know when it got there, but I do know that there's not a valid explanation, even from your expert. Without speculation, he can't confirm anything, and he does a test only on the stamp to suggest why that is absent in the scanning. Why only that? Miraculously, only the stamp.
Your Honor, I believe that if Your Honor would, the record itself, if Your Honor notices different renditions of the document that are submitted to different affidavits, the stamp appears in varying degrees. It just doesn't, it's not reproduced perfectly on a digital scan. And as far as the timing, certainly the expert was not tasked with determining the timing of when the stamp was affixed.
Oh, no, I'm not saying that the expert had anything to do with that, the timing. Would you just repeat what you said about the different stamps on what were you referring to? There's only one original, isn't that right?
Yeah, there's only one
original. And
original.
it was the original that was scanned, correct?
That's correct.
Okay.
That's correct. But as far as the timing and the propriety of the stamp having been applied before it was submitted for recording, the affidavits speak to that. Now, to Your Honor's point, that doesn't that raise questions of credibility? Call into
question all of the affidavits if you don't have not even one speck on the document that was supposed to have been scanned? Not one tiny speck.
I could just come back to the point that there's a reason why there's no spec is it's an electronic reproduction issue. I mean, we've presented evidence to demonstrate that what was physically presented did have the proper stamp, and we should be entitled to demonstrate that. If that is a question of credibility, we should have at least been entitled to present that at a plenary hearing or a trial, as a lower court initially decided when it denied both motions for summary judgment.
Counsel, is there any evidence that refutes what you're saying? You've submitted a number of affidavits that show the chain of title that make a prima facie showing, at least, that at the time the mortgage was brought to be recorded, it had a notary stamp. Has opposing counsel come up with anything, any issue of fact to refute anything you said about the chain of title, or submitted a contrary expert affidavit about the way that it was submitted?
No, Your Honor. And in fact, that expert report dated in January of 17 was actually supplied to opposing counsel in February of 17.
Does there have to be an opposing affidavit where the affidavit is conclusory and speculative? You have a blank page with speculation and conclusions. Does there need to be an opposing affidavit under those circumstances?
Maybe not as to the expert, Your Honor, but as to the other affidavits, I would submit that for there to be a true, genuine issue of fact, there needed to be affidavits in response, and there were not. The attacks on the affidavits were as to procedural issues, as to whether or not there were proper declarations made to be business records and so on.
Unless, of course, the absence of that stamp calls into question the validity of all of those other affidavits. Justice Kern has a question.
The only evidence that the mortgage that was brought to be recorded does not have a stamp is the fact that the one that was actually in the public domain does not have the stamp. Right?
Correct.
That's the evidence.
Correct, and that was our issue, is that basically makes it so that it's not just prima facie evidence that the digital version is irrefutable and conclusive evidence of what was submitted to be recording, and we submit that can't be the law, particularly when the ink original is available for examination and the parties involved with presenting it for recording are available for credibility analysis.
So if we had a
Yes,
trial,
for credibility analysis, meaning a hearing.
Yes, Your Honor.
hearing counsel, it would be the people who gave all those affidavits would testify. This is a chain of title. This was the ink mortgage. This was the notary's affidavit. This is the experts. And on the other side, there's nothing, right? Is there anything that refutes it as to what was brought to be recorded?
No, Your Honor, there was nothing in the record that would go on the other side.
Well, it seems to me the blank document. Anyway, your time is up. Let's get to Mr. Filosa.
Good afternoon, Your Honors. May it please the court, on behalf of respondent.
Counsel, what did you submit in opposition to all of these affidavits?
Well, in the first instance, Your Honor, we would take the position that, again, counsel's argument presupposes that there's a right non-pro-tunc to demonstrate or to cure a defect with an acknowledgement where...
But counsel, doesn't that assume that there's a defect in the first instance? Their position is that there was no defect.
Well, again, under the Recording Act, we're entitled, a subsequent purchaser for value is entitled to rely on the record as it appears in the public record. We're not on inquiry notice of a potential private alternate version of the mortgage. Inquiry notice of that fashion would undermine the integrity of the Recording Act.
Counsel, doesn't 317 though say that if it's in a form that's entitled to be recorded when it's presented, that is sufficient, and that then the case law suggests you should be on constructive notice of it if it was properly presented to be recorded?
Well, 317, Your Honor, uses the phrase, a document that is entitled to be recorded shall be deemed recorded as of the time of delivery. So entitled to be recorded is the $64,000 question here. A document that's not validly acknowledged.
I'll ask you the same question I asked opposing counsel. What evidence or what evidentiary dispute have you raised in opposition to their evidence that that mortgage was entitled to be recorded at the time it was presented for recording?
Certainly. Just in addition to the document itself, the doctrine of judicial estoppel. The bank submits sworn affidavits to its own foreclosure action saying this is the true version of the mortgage. And the mortgage that they offer into evidence in the foreclosure action is the one that omits any acknowledgement, omits any notary. They obtain a judgment of foreclosure in that action. So they are stopped essentially from adopting a contrary position. They got a favorable ruling in the foreclosure action on the strength of sworn evidence that says this is the mortgage, not some private alternate version of it. So from an evidentiary standpoint, they should be stopped from taking a contrary position.
They didn't get summary judgment based on the fact that there was no notary. They didn't take the position in that prior foreclosure action, hey, we don't have any stamp on this, but it's still a valid mortgage anyway. So what are you arguing they should be stopped on? The fact that they relied on that there was a mortgage?
No, the fact that the version of the mortgage that they presented to the court in the foreclosure action was the version that appears in the public record, i.e. the one that doesn't have an acknowledgement. So that's prima facie proof there that is the mortgage, i.e. the unacknowledged version is the mortgage, that there is no private, unrecorded, alternate version of the mortgage. They should be stopped from doing so because they obtained a judgment from a court on the strength of that evidence.
What about, why didn't you have an expert?
Well, again, under a summary judgment burden shifting analysis, the burden, in fact, never shifted to the respondent here. The Osborne affidavit, the expert affidavit, and I'll quote, says the absence of the notary might be attributable to quote unquote noise. Well, again, the phrase might be is speculative, it's conclusory, it might be due to the fact that maybe it was never notarized in the first instance. So on that basis alone, a speculative expert affidavit doesn't meet the summary judgment movement's prima facie burden. The burden never shifted.
Even if the expert affidavit wasn't there, don't they submit affidavits showing that there was an ink mortgage with a notary stamp, testimony from the notary saying that was notarized, I did notarize it. Putting aside the expert affidavit, what evidence have you put in to contradict of the chain of title or testimony regarding the existence of the stamp on the original mortgage?
Again, we don't concede that the bank demonstrates an unbroken chain of title here. We don't have the original bank who took the mortgage in 2005 before us. Chase They have an affidavit from Chase, who took an assignment in 2008. So we have no one at a point in time of 2005 indicating, yes, this is our mortgage, and the mortgage at the closing was acknowledged and properly notarized. Again, so we have the Osborne expert affidavit, which is conclusory. We have an affidavit from a bank that took title to the mortgage 3 years after the fact, where the operative point in time is April 2005. The title closer affidavit is also conclusory because, again, she relies on custom and practice, where the Galetta case from the Court of Appeals says when you rely on so-called custom and practice, you have to, with specificity, entail, I as a notary, ask the signatory to present their driver's license, present the form of photo ID, or I ask someone else to vouch for the person's identity. We have no such testimony from the notary here. She just said, that's my signature. That scribble is my signature, and I wouldn't have signed it otherwise. But again, no custom and practice evidence. So from a summary judgment
But that's not
standpoint,
the only affidavit. There's an affidavit with Caliber Home Loans, the bank attorney, which discusses the inked original of the mortgage. But there are a number of affidavits here, no?
Sure. Well, certainly there are a number of affidavits, but again, the Caliber became the mortgage servicer in 2014, when again the operative time being the April 2005 closing. So purely from a business record standpoint, the Caliber affidavit is pure hearsay because they're relying on 7-year-old records that they onboard, but they don't make the 4518 business record showing. So for that reason alone, the burden never shifted under a summary judgment rubric.
Mr. Patel?
Yes, thank you, Your Honor. Very briefly on the affidavit of the notary. The notary's affidavit does not just simply say that's my signature. I recognize that. I recognize my handwriting. And we submitted that it does meet the Galetta standard because although it did not go into the specificity of what the notary does to the level that Galetta called out, it went into the specificity of what the notary never does. And that was the specificity that meets the requirements of Executive Law 137. And so we submit that that was sufficient to meet the Galetta standard. But nonetheless, the trial court initially said, okay, I need to have credibility hearing on that. Coming to the suggestion that there's no one from the bank saying this is the document that was submitted for recording, if we were to take that position, we would often never be able to prove anything because there are so many banks that are not around from 2005. But more importantly, in this case,
I don't think that's the problem. I think it's the record keeping. You're saying because the bank doesn't exist. Well, the bank is supposed to keep these records and appropriately transfer them to the other part. Yeah.
Right. And also on that point, we have the affidavit of the title company who received the money to record, who prepared the document to record and presented it for recording, saying this is the version of the document that it appeared with the notary stamp before it was submitted. And finally, on the issue of the buyer, ADP2L, being a purchaser for value, not charged with notice, it's important to point out here that at the time that the buyer bid for the property on December 10th of 2014, its own title report reflected the open mortgage and an active lis pendens in foreclosure. And so this was not a situation.
The lis pendens was expired before the buyer got his deed. Didn't it expire before then?
Yes, it did, Your Honor, in the gap. It did. And on that point, we submit that at the time the bid was made, the lis pendens was valid, and case law suggests that at the time a bid is made, a party takes equitable title. And so while it might have expired 4 months later when the deed closed, the lis pendens was there. And at that time, if someone looked at the public record, one would have seen there was an active foreclosure. And the point here is this: it's bedrock law that one cannot claim to be an innocent purchaser for value if they are on notice of an adverse claim to the same property they seek to get an interest in. And that notice is indisputable, not only actually, but constructively at the time that the bid was made. Thank you.
Thank you both.
Thank you, Your Honors.
That was the last case of the day and argument. This concludes our argument for today. Thank you. Court is adjourned.
Thank you.